committee members, liaisons, and members of the public to the Legal Services Trust Fund Commission Rules Committee meeting. Thank you for joining us. We are using Zoom with the goal to foster a more inclusive environment and effective meeting. If you would like to comment during the meeting, please use the raised hand feature. Please utilize this tool to virtually indicate that you would like to speak in order to help the chair facilitate the discussion. A friendly reminder that this is a video conference and to please be aware of your surroundings behind you. All Legal Services Trust Fund Commission and committee meetings will be recorded and posted to the State Bar website. Zoom captioning is available. To enable, select live transcript at the bottom of your Zoom screen. Then select enable auto transcription. Thank you very much.
Thank you, Angela. And we're still waiting for Erica. We don't have quorum. So I think if everyone will bear with us, just we'll hang out for a minute or two. Okay. See, Erica. Sorry, okay, Erica's here. No problem.
I was like sliding into my WeWork.
No problem. So Erica, we do have quorum right now. So okay. Angela did the housekeeping, and then
let's take roll call.
Okay, great.
Thank you.
Al-Sarraf. I
think Amin said I saw an email from
him. Okay, just saw the email now. Thank you. Fightmaster.
Here.
Blakemore. Catherine says she's running late. Bushelli. Campbell.
Here.
Galkin. Meeker.
Here.
Milrod.
Here.
Connolly.
Here.
So we have quorum. Let me do our liaisons. I think I saw Zach and Lauren on. And then I see any of our Judicial Council liaisons. And then State Bar staff, Elizabeth's on, Crystal, Heidi. Great. We're all here. We'll turn it back to you, Erica.
Great. So I think the first thing on our agenda is minutes from the last meeting. Is that correct?
Yes, Jim has his hand raised, and we also have, I believe, a member of the public.
Oh, sorry. Yes, you're right. I totally forgot about public comment. Jim, do you mind if we do public comment first, and then we can?
Sure.
Awesome. Thank you. Sorry for the wrinkle. Why don't we take public comment? And just as a heads up, we'll take public comment now. We generally try to limit it to about 3 minutes. And obviously, if it's related to something that's coming up later in the agenda, we also welcome whoever's the member of the public to stay on the line if they want to, in case we have questions later. Anyway, go ahead.
Good afternoon, all, and thank you very much for the time to speak. I actually attempted to send prior written public comment to the only email address of a committee member I could find, which is Mr. Meeker. I'm sorry to put that on you, Mr. Meeker, but you actually should have my written public comment in an email to your uci.edu email.
Where did you send it?
It's I couldn't find an email address. There's no email address actually that's posted on the request for comment for the committee meeting. So generally speaking, the bar has these email addresses that are available so you can you submit your public comment prior to the meeting, but your committee doesn't have that. But at any rate, I don't want to take too much time because I know you guys have a busy agenda and you guys have been very kind so far. So here's my comment. I'm really commenting because I've had an issue with the Client Security Trust Fund. Part of that issue, of course, is about the policies for applicability and routing. And part of it is the way the trust fund access is granted. So to be brief, again, my name is Todd Hill. I recently sent a notice of violation regarding Title IX issues that are longstanding, over 4 years from my perspective, and at least 7 years from my alma mater's perspective, the People's College of Law. As of today, after more than 4 years of legal study, I have never been in possession of an accurate transcript. The reason for this, I believe, is due in large part to the misconduct or negligence of State Bar agents and operatives. And I say that, of course, without that being a legal determination. Here, multiple notice violations and requests for correction have been submitted. And I started submitting specific requests to the State Bar, who put the school on probation in December 2022 and January of 2023. Although my transcript issue, my first notice of violation and first notice of issue was in 2020. And I will remind you today, we are sitting here in August of 2023. So I'm trying to transfer. I'm trying to get federal student aid. I can't. The school took my money. The State Bar ordered them to disgorge the money. The school will not disgorge the money. The school will not give me a transcript. I made a complaint. Now here's where we get to you guys. I made a complaint to the State Bar about the conduct, right? Because it does seem odd. I think if anybody here has gone to any post-secondary institution, I think they would find it odd to never, after having completed the entire curriculum the school offers, never having had a transcript, not having one today, having schools saying, hey, I need a transcript, and the State Bar cannot provide one. And I also have to apply for federal student aid because I haven't gotten my money back.
Excuse me, it's been 3 minutes.
Okay, so let me finish. I'm almost done. 30 seconds more. I appreciate you. So basically, the issue is this. I filed a complaint. The complaint is closed. The complaint includes a State Bar actor. The complaint is closed by State Bar. And so even though today I still do not have a transcript, after requesting it from the bar, the sole regulator in the sphere, in excess of 3 years, I go to the Client Security Fund to say, hey, maybe you guys can pay me because I have a family too. I have young children.
Mr. Hill.
And they say that I'm not qualified for the Client Security Fund because the State Bar has closed my complaint.
Yeah. So, Mr.
Okay.
Hill, yeah, thank you for the public comment. And I'll just note that the Trust Fund Commission sort of handles grants to legal service organizations. We aren't really sort of party to kind of regulations of the law schools or you know, any of that area. We don't really have oversight on that. So I wish you luck in resolving your complaint otherwise, but it unfortunately isn't the purview of this committee at this point. And I just, for general notice, I'll just say that we do have, you know, on our agendas, we do have an email address for any public comments, which is the lstfc@calbar.ca.gov. So in the future, if there are written ones, that would be where they should be directed. Okay, any other members of the public?
No.
Okay.
I don't see, but I do want to know, our committee member, Will Bashelli, is here in the attending pool. Boy. Will, unfortunately, because you didn't notice your location, you can participate as a member of the public, but not as a commissioner today.
Okay. Thanks. And obviously, you know, if you have comments as a member of the public, we'll definitely, please raise your hand when we're talking about stuff. We appreciate the commentary. Okay, so we did public comments. Now we can move to approval of the minutes, and Jim had his hand raised. Yeah, what's up, Jim?
Yeah, two minor things. One is, Dwan, I forwarded Mr. Hill's email to you, so you can forward to whoever's appropriate.
Thank you.
And two, one minor change on the minutes. At the very top where you talk about members present, I'm labeled as Jasmine Meeker. I usually go by Jim or James.
So sorry, that's a very big typo. That feels like an autocorrect mistake.
Thanks, Jim. We didn't end up with a new member named Jasmine. Okay, any other changes or comments on the minutes? Okay. My suggestion is I would entertain a motion subject to the amendment that to the minutes that Jim highlighted. Is there anyone who'd be up for making that motion?
I'll move.
Okay, thanks, Jim. Any seconds?
I'll second.
Okay, thanks, Louise. Okay, let's take our vote.
Al-Sarraf, Fightmaster.
Yes.
Blakemore.
Yes.
Bashelli, Campbell.
Yes.
Galkin. Meeker.
Yes.
Milrod.
Yes.
Connolly.
Yes.
Motion passes.
Great. Okay, let's move to the meat of our discussion today. And I'll note that we're going to try to wrap this up by around 2:30 if possible. But obviously, if there's a lot of vigorous discussion, you know, we can go until 3. But to the extent I know some members and staff have a meeting coming up, so we want to be try to be cognizant of that. So why don't we start with the pro bono allocation, and of course I'm going to blank right now on who it's supposed to go to. Dewan, can you help me out?
Yes, it's Angela.
Oh, Angela. Hi, Angela. Sorry about that.
No problem. So
please take it away.
Okay, let me share screen. One moment. Does that look for everyone like a shared screen, I imagine? Okay, most excellent. So thank you for the introduction. And as you've heard, my name is Angela O'Hara, and I'm a Senior Program Analyst in the Office of Access and Inclusion. And I've been working on this pro bono allocation topic with the working group for the last few months. I'd like to take just a few moments to thank the working group for their efforts. So Amin, Louise, and Jason have been participating with me on this topic. The memo that you received in the meeting packet is the culmination of the working group's efforts. And today we will review the issues the working group took on and their recommendations and some proposed rule language. So let's get started. Before we dive into the 3 codification issues that are on the table, a quick reminder of purpose. So the IOLTA statute's purpose, as I know you are all aware, is to expand the availability and improve the quality of existing free legal services in civil matters to indigent persons and to initiate new programs that will provide services to them. Important to this goal is the promotion of pro bono legal services. Pro bono allows the legal aid system to leverage the resources of the private bar to increase access to legal services for low-income Californians. So with the purpose as its foundation, the Rules Committee took the opportunity to examine the pro bono allocation tests and explore options for promoting equity, transparency, and clarity. The 3 codification issues on the table are whether to eliminate the substantial numbers threshold test, that's 1. The next one is whether and how to modify the principal means tests A, B, and C. That's the second one. And the third is clarifying definitions that impact how roles are considered. and this would include non-attorney volunteers, law students, and legal fellows. For each issue and sub-issue, I will provide just a brief overview, as I know you've read the memo, of current practices, considerations, community feedback, and then the working group's recommendation. And I will pause after each recommendation to invite the working group members to add comments and then take any questions from the larger group. So with that being said, we will first get into governing authorities and past efforts. So we don't need to go too much into the IOTA statute that I know you all live and breathe, but it does provide for the allocation of funds to pro bono programs. And specifically 6214B3 Cap A specifies that this is achieved through the coordination of the recruitment of substantial numbers of attorneys in private practice. And 6216B1 Cap B specifies that qualifying organizations must have pro bono as their principal means of delivering legal services. So that's where the statute speaks to pro bono allocation. And no state bar rule speaks to the pro bono allocation, just of note. However, the eligibility guidelines are where the tests are outlined. So the substantial numbers threshold test and the principal means tests A, B, and C. So I'm going to go into those a little more deeply so you understand the current state and the context from which the working group was trying to understand the current state. So part one is this substantial numbers threshold test, and this comes from guideline 2.6.3.1 in the commentary. And the threshold test determines whether a QLSP has a baseline substantial number of pro bono attorneys. And this is evidenced by whether they've recruited at least 30 attorneys in the previous calendar year, or recruited 5% of the county's attorneys, or the attorneys they've recruited have donated at least 1,000 hours of legal services. So that's the substantial numbers threshold test. I see James has questions. Let me just complete one thought and then I will happily take that. But if an organization does not meet this test, it cannot proceed to the principal means test. So, James.
My question is that number 2 of the part 1, recruited 5% of the county's attorneys. Does that include all attorneys or just like retired attorneys as well as practicing attorneys? And is that, when you say of the county, does the attorney have to live in that county, or does the attorney have to practice in that county, or could it be either or?
So right now our practice is that, hi Jim, our practice is we would refer the grantee to the State Bar's website where we have a listing of the number of attorneys by county. And so it would be based on that number. And I believe those are active attorneys practicing in that county, or let me take that back. I believe those are active attorneys whose kind of official address is in that county with the State Bar.
Official address. Okay.
Yes.
Thank you.
Mm-hmm.
Thank you, Jim. So moving on to part 2. So as I was mentioning, that's the threshold test. And in part 2, if the threshold test is met, then an organization must proceed to the principal means test. So this is sort of the part 2 of this. And it can do this by meeting test A, test B, or test C. So it just needs to meet one of those tests. Test A is pretty straightforward. And these come from 2.9.2 in the eligibility guidelines in the commentary. Test A is just simply pro bono attorney hours exceed staff attorney hours. So that would qualify an organization. Test B is that pro bono attorney hours and paralegal hours exceed staff attorney and paralegal hours. And then the second part is that pro bono attorney hours are more than half of staff attorney and paralegal hours. So that's test B in its current state. And then test C is describe and explain the method used to demonstrate that pro bono is the principal means of delivering legal services. That's the direction that's given to organizations. So it's the current pro bono test from the eligibility guidelines. Now that we've done governing authorities, we just briefly review past efforts. I just wanted you to be aware of this, that a previous version of a pro bono allocation working group presented to the recommendations to the Rules Committee on April 23rd of 21. And there was a memo that offered proposed changes to the guidelines for the pro bono allocation. And after discussion, the committee made the following recommendations: to eliminate the substantial numbers threshold test, to clarify that legal fellows who are attorneys are counted as staff attorneys, and that organizations may explain the impact of these temporary staff on their reported staff hours as part of Test C if necessary, to allow applicants to count law students as pro bono volunteers, even if they receive a nominal stipend for their work, and to establish factors for the Test C analysis. The Rules Committee at that time delegated further revision of the principal means test and clarification of rules back to the working group for further investigation, analysis, and recommendations. So at this point, the focus is to codify what was previously only in the eligibility guidelines into state bar rules to ensure all grant requirements are contained in the governing authorities. So that was all, that's the sort of background, setting the table, which brings us to issue number 1, whether to eliminate the substantial numbers threshold test. So as I mentioned, I'm going to just do an overview of the contours since I know you've read the memo. So some considerations, there is no statutory requirement for 2 separate tests. And Catherine, I see your hand is up. Would you like to wait until the, okay. No statutory requirement for 2 separate tests to determine eligibility. The test does not provide a realistic opportunity for some grantees. So this is an important one to bring forward, that the numerical approach may not allow for this dramatic difference in size and composition of organizations, and just this, wholly uneven distribution of attorneys across geographic regions. So notably, 22 of the 58 counties have fewer than 100 attorneys, and attorneys can range from 4 in some counties like Alpine to 57,309 in LA County. So quite a range there. So I mention these specifics because a QLSP in a rural area with few active attorneys may not be able to recruit 30 attorneys, obtain 1,000 pro bono hours, or recruit 5% of the county's active attorneys if these attorneys already work at the QLSP, are conflicted out, or just don't have the bandwidth to volunteer. And then the substantial number of attorneys requirement may be adequately measured by the principal means tests, test A, B, or C. So the thinking is that adding language to test C requiring organizations to demonstrate how it recruited substantial numbers of attorneys would sufficiently meet the statutory requirement. So Catherine, since you perched and ready to share.
No, I think I'm just, so I appreciate there isn't a statutory requirement for 2 tests, and I'm not necessarily saying there have to be 2 tests, but is the standard that's proposed going to say you have to have not just recruit substantial numbers, but you actually have to have substantial numbers of attorneys that are pro bono, right, as one part of the test, and then still maintain and you have to have this be your principal means of delivering legal services, or are we conflating those in some ways? So they seem like 2 different standards to me. You have to have substantial numbers and you have to have that be your principal means, but I'm a little unclear, having read all of this, if both are being retained or proposing elimination of one part of that standard.
So this would be fast forwarding a little bit to the proposal at the end, but it is the recommendation is that there is are 2 options. There's either you just demonstrate simply that there are the number of pro bono attorneys exceeds staff attorneys, or the organization would be required to answer the factors in a separate test that would demonstrate how many attorneys they would be providing that specific information.
So you could either qualify as having a substantial number, or you could qualify as having it be your principal means, because I sort of read this to say you're getting rid of the threshold test, but you still had to have a substantial number, and then it separately had to be your principal means.
My understanding, and I would welcome that if any of the working group members are on the call at this moment. I don't think we have Jason or anyone at this point, but my understanding is that both things could be achieved through either the test A, which there's an assumption in test A that it's if you have if your number of pro bono attorneys exceeds your staff attorneys, that the interpretation of that is that you that is your principal means. You have substantial numbers and it is your principal means, or through the other option, answering and clarifying the factors, you would be really demonstrating your commitment to pro bono. So it would be, you know, showing how many pro bono attorney hours you have, and the other factors, which we'll get into specifically later.
So if you recruited 10 and you only had 5 staff attorneys, regardless of the amount of work your pro bono attorneys did, that would mean you met the standard. So even if they did far less work than your 5 staff attorneys, you would be eligible for the pro bono allocation because you had more attorneys than pro bono attorneys than you had staff attorneys.
I don't think that's right. I think in test C, with the additional factors that are being suggested, it would be trying to get at both substantial numbers and principal means.
So you have to have both that was really my first point, which I thought I was told I was inaccurate, that you have to have both a substantial number, but we're no longer going to use a test that says how it's not just a numeric test, right? And it has to be your principal means. So you still have to meet a substantial number and you have to meet the principal way of delivering services.
I think that's right. And I think the working group, and if working group members are present and wish to chime in, the working group wanted to not just have like the substantial number be as strict as it has been, because it does have an impact on some of our rural programs. And so they wanted to kind of like look at substantial number kind of more holistically, along with other factors that are listed in test C.
Okay, and then my second sort of preliminary question is, when the rules committee was when the eligibility committee was meeting, what was expressed is that the current test C did not apply to new programs who are applying for a pro bono allocation on an initial basis, that had been the interpretation of the kind of the informal rule of the staff. And so they, at least previously, had to meet test A or test B. So is this new rule designed then to apply both for current programs who are reapplying as well as for new programs that are applying? Because that wasn't clear to me either.
The working group didn't discuss that point specifically, but I think that a new program could qualify under test A or test C.
Yeah, that's my understanding. I think maybe the confusion is with the test C, with our current programs, there's just more history to cite. For instance, that they have received the pro bono allocation for a number of years. New programs can't do that. But I do think, like, if it was a new program that came through and it was a rural program, existing office practice, that they could probably utilize test C and make probably a pretty good, compelling argument.
Yeah, I just think if we're really, I just think the clarity becomes really important, right? So if this is the new test, it sort of seems to me you should be able to apply under either one and be considered whether you're a current or a new program. But I sort of found the rule not to be particularly clear about that. And since we're really, I think in some good ways, changing how we're approaching a pro bono allocation, I think potentially with a desire to encourage other programs to apply for it, if they're in fact using this, or to make it easier for programs that have been excluded from, as you said, Juan, rural areas, then we just need to be clear about who does it apply for in the rules themselves, so that all programs sort of understand that. Anyway, I see Jim's hand up. So
no, and I don't believe we were making that distinction. Angela, you can clarify in the working group, but we can certainly make it more obvious, and maybe we can write it into the next version of the memo for the commission.
Well, I just think it's important because, at least as it was explained to the eligibility committee, is that was not the current office practice. So that's the reason for really asking for clarity, since that committee has to implement whatever these rules are, right? So
thank you.
Thank you.
Thank you. And Jim?
Yeah, a question on the third point where you say the substantial numbers of attorneys requirement may be adequately measured by A, B, or C. Are there any programs that meet the substantial numbers of attorneys test but do not meet test A, B, and C?
Well, hold on, I'm just offhand.
I feel like if you meet tests, I think the answer to your question, Jim, is no. Because if you have substantial numbers, you would meet those tests.
But I guess that was my question though, Elizabeth. So if you had 10, which is more than the number of attorneys, but your 10 didn't really do that much work, does that, I don't know that means it's your principal means of delivering legal service. I actually think, at least in this new construct, that's why, to me, saying you have to have a substantial number and it has to be your principal means are two distinct concepts, and you actually need to meet both of them.
I think that's a good point, that we should be more clear that even though we're eliminating the threshold test, the qualifiers are both still exist.
Yeah, thank you for that. That's you said it much. Yeah, you're just very clear. That was really helpful.
Okay.
I think.
Yeah, no, thank you.
That clearly. So.
Yeah, can I make a request? Can we move? I want to see the actual rule. I'm sort of going through the memo and trying to refresh my memory. Do you mind? Oh,
just so I'm understanding correctly, so it's not requirements may be adequately, it is are adequately measured by test A, B, or C, right?
Yeah, forgive the phrasing just wasn't ideal there on that bullet, but that's the thinking, is that the principal means test adequately capture this concept of substantial numbers of attorneys. And then I do just also want to clarify that it's not a number of attorneys, it's that was in test A, it's hours of attorneys. So just to clarify that. So Eric, are you asking in this moment that I sort of fast forward to the rule language, which I'm happy to do?
Well, we're just talking about the rule language a lot, and I think it might be useful to maybe have it up while we're talking about it.
Angela, I don't know, you're breaking up for me, no one else is, so I don't know, maybe no one else is having the problem and I'll just cope with it, but you were harder, you just break up.
No, that's heartbreaking. I certainly don't want to break up.
I don't mean it to be heartbreaking.
We've only just begun. Okay, so my hope is that I don't break up anymore. So this is the rule language.
Sorry to hijack your presentation. I'm sure it's very good, but given that Catherine's asking about the rule, I just thought it'd be useful to have the rule so that we could see. So basically, the whole thing is you have to either meet the A or the B.
Mm-hmm.
Got it. And so with A, the idea is that there's got to be objective evidence that the attorneys recruited provided. So is the fact that the number of hours exceeded the staff attorneys, is that how you're going to hit both, that you recruited substantial numbers of attorneys and that it's the principal means?
But I think you have to go back to what's under F. I mean, to Jim's point, it says may show that it recruited substantial numbers of attorneys. You have to you shall show that you recruited substantial numbers of attorneys and that pro bono is your principal means. So it's not, may sounds very permissive. So in reading may, I don't know whether it's like you may show one and not the other, or I think you actually have to show both.
Well, I think this is where I'm a little bit confused, I guess, with the structure. Is the way I read this is like F is saying you may show it by you may show that you recruited substantial numbers of attorneys and that you have principal means by either doing A or by doing B. And Catherine, you're saying you should have to meet both A and B in order to show you did substantial numbers and principal means?
Well, just there's two, I guess, does B go to the, I don't know. I just find this confusing because there really are two tests, substantial number of attorneys and your principal means.
And I think what
get conflated a bit.
And I think what might help is some more clarifying language that if you're able to show more volunteer attorney hours than staff attorney hours, then the presumption is that, or you've shown substantial numbers, but then the presumption is that your primary means is pro bono.
Got it. So in other words, if your staff attorneys are providing more hours, if your pro bono volunteer attorneys are providing more hours than your staff attorneys, you are presumed to have met both of the tests that the statute requires. You've recruited a substantial number and it's your principal means. That's why A satisfies both.
Yes.
Okay. I'm not making an opinion. I'm just trying to make sure I understand. Sorry, Dawn, you have your hand raised.
Yeah, but I do agree that with Catherine or Jim that said that because the way it's drafted, though meeting one of it, that's not super clear, Elizabeth.
I'm hearing that now. So we can definitely add more clarifying language. That there's two tests, and this we hope the rules revision will simplify.
Okay. And then if you don't have more hours, if your volunteer attorneys don't have more hours than your staff attorneys, then you can try to make this narrative description explaining why all of these factors show that you recruited both a substantial number of attorneys and that your principal means. Yeah?
Yes.
Got it. Okay, sorry, Jim, go ahead.
Yeah, what's the impact of this rule change? Will it substantially increase or decrease the number of programs qualifying for pro bono?
Well, we don't know exactly. We hope that it will increase the number of grantees that qualify for the pro bono allocation, because we know that there are some grantees that don't meet the threshold substantial numbers test, so they can't even get to the test A, B, and C portion to show that their principal means is pro bono. So we think it will increase the number of participating pro bono grantees.
Yeah, we think it will increase. We don't know how many, and it's also this test has been confusing, and so there are probably programs that would be eligible even under the existing that don't know it, and certainly under the new one would be eligible because it's more flexible, even in rural areas. So I do think it's going to go up.
Yeah, Catherine, go ahead.
So I guess what I worry a little bit about, and I maybe it can't be fixed as a piece of this, it's if your pro bono attorneys are the people that are giving your free legal advice and your numbers of staff attorneys and pro bono attorneys are clear, but your staff attorneys are doing kind of the more significant work of the organization, right? I don't know that I just think the fact that you have more, you've sort of taken one factor of like the test that was the original just the substantial number test and said that's enough. And I don't know if I think that's just enough, just that sheer number. And it's sort of never been that way before, right? So it's just a presumption that if your pro bono attorneys did 10 more hours of work than your staff attorney, that's your principal means. And there's nothing else, there's no other inquiry, they're just automatically.
But I thought that was what test A and test B already did for principal. Those way
there was a different, you had to
No, you had substantial numbers was different than principal means. For your point, all I'm saying is like, it's always been an hours thing for principal means. And then if you didn't have more hours, then you went into test C. But like, that's the current one, is that you had to meet substantial numbers through the, Angela, can you go back to the?
You had to have two things. You had to have a substantial number of attorneys and they had to do substantial hours, right? That there were two parts.
They had to do more, but you're saying you don't like that the hours is the problem. And I'm saying, but the current test already does in hours to show principal means. So you had to recruit 30 attorneys. So the first one was, did you have substantial numbers? So you recruited 30 attorneys, you recruited 5%, or they donated at least 1,000 hours, right? And then if you met that, then as long as your pro bono hours exceeded your staff attorney hours, you qualified. So that didn't get into the quality of the work already. That's the current rule.
Right, but you could only have 2 pro bono attorneys. You could be a very small program and have 2 pro bono attorneys now and 1 staff attorney, and you would be eligible. And is that the outcome we want? And
well, you wouldn't be eligible, Catherine, in this scenario. Those 2 pro bono attorneys would need to have more hours contributed.
Yeah. So if they have 5 more hours than the 1 staff attorney, then you're eligible, right? So you don't have, I mean, the number of lawyers that, so you really, if you just sort of say, what are the, even if they're out, what are the examples that under that test would qualify is you're a very small program, you have 2 pro bono attorneys. I think there is kind of such a program in that I did a review of. You have 2 pro bono attorneys, you have 1 staff attorney. The 2 pro bono attorneys do 5 more hours than your staff attorney, you are automatically eligible without any further showing.
Yes, I believe that's, yes.
So your concern then is the substantial numbers prong, not the principal means.
Yeah. I got the hours and the numbers conflated.
Are you concerned, is it the substantive or the hours?
I guess I'm really just trying to make sure I at least understand how the rule changes this in terms of who's going to be eligible and what the implications are. That's really what I'm trying to understand. I'm not necessarily trying to say like yay or nay, really just trying to say, and sometimes it's helpful, I think, to sort of choose like for a very small program, like, you know.
So what you're worried about is like, you're in LA where you have lots and lots of attorneys. You only recruited 2. They gave you more, they did more hours than your staff attorney.
By a small amount.
Pro bono allocation. That would be the hypothetical that would be concerned, right? Like, it's fine to do the 2 and 1 when you're talking about a rural county where there's only 5 attorneys total, right?
Right.
But maybe not in like a big county. I mean, that's a fair point. Yeah. So what did the work, Angela, sorry to put you on the spot, but like how what's the sort of view, and was there any feedback from LAC on that kind of stuff, on that issue?
It's not specific, the things that Catherine is raising that you're sort of discussing. I don't know if I have specific comments from the community on that, or whether the working group really wrestled with that even specifically.
Can I help?
You know,
can I help out? So yeah,
sorry, I'm not.
No, that particular example didn't come up, that Catherine, but I do, from sitting in those working group meetings, I think the general sense was trying to come up with something that was easy for programs to apply. Yeah. And yes, that scenario to me would have been applicable. If this rule went, the new rule, that would have been fine. That my sense of the working group, that they would have been fine with that approach. Elizabeth, if you want to chime in.
Yeah, I agree. They didn't talk about your specific scenario, but I think they did want to simplify, you know, the application and qualification process for this.
Okay, and then so then I guess what's the implication for so there's 10% more. I'm not actually recalling how the 10% more gets divided. So
it's divided pro rata.
Based on
QE, qualified expenditures.
Okay.
I mean, I guess the question to me is, what does it mean to recruit a substantial number of attorneys? Is that a substantial number in the whole county? Is that a substantial number as in like compared to how many you employ, right? Yeah. I would point, if you employed 1 and you recruit 2, you did double, right? So that feels like it's substantial. So that I think is part of the question, right? Is like, and do we have any sense of,
I think the working group didn't feel like substantial number as currently, you know, 30 attorneys, 5%, 1,000 hours was like equitably applicable across counties. I think the current working group, as well as the 2021 working group, kind of had the same view on it. And that's why they wanted to.
I was on the 2021 working group, I believe, with Eric Iskin.
So
I have the same problem.
Yeah, so I believe that's the reason, the rationale for eliminating substantial numbers, because that is hard to quantify across 58 counties. So I mean, I think, you know, Catherine, your scenario is a really valid one to be concerned about, and we can go back to the working group and discuss further if that's to distinguish that.
Like it's sort of the distinction between rural. So I appreciate the challenges in rural communities. That's come up a lot in the eligibility and budget reviews when we're looking at pro bono. It just seems that I guess I just want to make sure we've thought about the permutations of this and what are the maybe unintended consequences of another program getting pro bono allocation. That means other programs in the county are going to get less of a pro bono allocation, even though like in LA County, you know, that other programs are going to get less because there's a lot of pro bono partners in LA, for example.
And if I can add, I think what the working group where it wrestled the most, not so much that what you raised, Catherine, isn't invalid, but I think where they struggled was you have a rural program that obviously it's difficult to recruit in rural area, but their numbers of volunteers, their sheer numbers of volunteer is so little, even though it took them a lot of time to recruit that. At what juncture are you just saying, as long as you're rural, you get a pro bono allocation versus like, is there some standard? I think that was more of the, I think the philosophical question that the working group was struggling with. Not that what you just raised, Catherine, wasn't important in terms of like, that seemed a little bit of an easier justification if they have substantially more of pro bono attorneys versus staff, that was an easier way to justify and felt fair. I think the equity issue in terms of if it's a rural program and, you know, their staff is eclipsing it by 4-fold or 5-fold sometimes, but they still expended a lot of money to get those few kind of volunteer. Do they still get a pro bono allocation? I think that was the tougher question.
I think that's the question that comes up under test C, kind of, right? I mean,
the test C. At what point isn't enough to make test C, or are you just because by sheer fact that you're rural, you will get it if you apply? That I don't think that's a different construct,
right? I mean,
more.
Like if we're trying to solve a rural problem, which I think is real, given the combination of the fewer number of lawyers and where those lawyers probably choose to spend their time, that is a real problem, right? And so should there just be a rural rule versus a rule that applies for everybody? Like, and you define, when we have definitions of what are rural counties, I guess that's just a different way of looking at it.
Zach, have your hand raised.
Yeah, I was just going to say really quick, I don't know if this is fully on point, but at one of the recent meetings, I believe it was Legal Services of Silicon Valley, was one of the only organizations denied under Test C.
Yeah.
And they were kind of just getting their pro bono program up and running with some new staff. And under Test C, I think they had made the argument that their pro bono hours or number of attorneys was about 3.5 times that of either their attorneys or the attorneys' hours. And so they were trying to make the argument that that was sufficient. And so I think under the new Test C, that'll hopefully help orgs like them that are kind of trying to start a program have more clarity. The other issue was that they couldn't demonstrate that they'd already kind of had a commitment to pro bono because they were trying to start this up. And the other aspect that just reminded me of this, Catherine, to your point, was that's obviously a pretty urban county with plenty of pro bono volunteers available. So I think the committee at least was wary of accepting their application based on the fact that even though it was 3.5 times or whatever, it still didn't really show that they had really tapped into the volunteers available in that county. So I don't know which way that goes for this, but that was just a recent example of an org that was denied the funding.
Yeah, that's why I asked the question, is this the standard for new organizations and because that's exactly the question that came up when we last did the eligibility and review. And, I think at least in my head decided the staff said the Test C didn't generally apply to new organizations and it's up for a discussion at rules. Let's just deal with it as a rule, not like do a one-off in a eligibility review, right? For consistency. So.
Yeah, I think my recollection was that the reason the Test C was generally not used for new programs is because you needed to show sort of a history of how, which I think is what we already said, that you had to show how it was an example in the past in order to demonstrate what you were going to do going forward. But now it seems as if under the proposed rule, the now Test B is essentially the Test C from before, you could sort of do proscriptively what you're planning to do, right? Is that the idea?
With more specificity and guidance, so that factors were described.
I don't think, yeah, sorry, Angela.
No.
It seems as if, like, just to make sure I'm going to make clear, does anyone have any objections to the B part of the test, which is essentially the test C?
I think, I guess I wanted to understand the factors that, I mean, it's just, I guess my other observation is the landscape, at least as the programs describe it, post-COVID has really changed, right? And like a very long-standing pro bono program, their number of hours continues to go down, even though they have, you know, like, I don't know, 800 and some pro bono lawyers, let's say, right? And so there's certainly value in that, but like sort of making sure that these factors actually lead to us being clear that it is, these are the things you would need to know, that it is your principal, like your primary way of delivery, because in these programs, given the increases in equal access and IOLTA and this other funding, like very often the number of staff hours can exceed the number of pro bono hours. And so is that okay?
Yeah. Sorry, Angela, can you bump it forward one more? I want to see the actual rule, if you don't mind.
Okay, the rule, yeah.
I want to see what the factors are in the rule, sorry.
Yes. So
your recruitment and retention strategy, your training curriculum, type and number of volunteer opportunities, the service delivery model, supervision and scope of support, and data demonstrating a quantifiable commitment. I mean, obviously with this, you wouldn't, if you had more hours, you would be an A and then it would be done, right? So this is only for people who don't have more hours.
Yeah.
Who pro bono attorneys don't have more hours.
Or cases, right? That's the other, like in terms of data, like if there's like a high volume of cases where we use pro bono attorneys, even though it may not count hours wise.
Even though I'm sorry, they may not count hours?
Not count, sorry, I used the wrong word. May not, you may have a high volume of cases where there are pro bono attorneys participating, but not a high number, but that may not equate to a high number of hours.
Got it. So they're simple cases or whatever, and your staff attorneys are handling some big class action or something like that.
Or perhaps if you have a lot of clinics, you serve a lot of clients through your clinics. So maybe it's not a lot of hours, but it serves a lot of people.
Got it. I mean, for me, the factors make sense in B, but I'm open to other suggestions. To me, the bigger question is the A, the sort of standard, you know.
So is it that staff attorney hours pro bono attorney's hours exceeding staff attorney hours is not sufficient to demonstrate principal means of providing services pro bono? Is that correct? Is that
substantial numbers of attorneys being recruited?
Substantial number, okay.
Because actually under A, to Catherine's point, right? Like if you have 2 staff attorneys and 1 pro bono attorney, but your staff attorneys work half-time, but your pro bono attorney worked overtime on whatever case, they could end up, so you recruited 1 pro bono attorney, but their hours are actually more than your staff attorneys for whatever reason. They took the big case or whatever. That makes sense to me as a principal means, but have you recruited a substantial number of attorneys? That's sort of the question for me under A. And like, maybe that's okay because a substantial number of attorneys is 50% of your staff. I don't know. Like, again, what does substantial relate to? Is it the number of attorneys you have? Is it the number of attorneys in the county? We've usually done it based on like a raw number, right? That 30 was substantial, or 5% of the county, or 1,000 hours. So we have done hours in the past, which sort of belies, which explains why why the working group went to hours exclusively, because the threshold in the past has been hours in order to show substantial numbers. of attorneys. But I think the assumption is 1,000 hours. I mean, I guess in theory, you could have one pro bono attorney do 1,000 hours. Actually, that's a really interesting point. If you basically had some retired pro bono attorney, a retired attorney who was like, I'm just going to do pro bono for this like organization that I like, and I'm going to donate 1,000 hours of it. And there's 2 staff attorneys, and then you get into, and they happen to do half time. I think they could already qualify under the current test, couldn't they?
The current test, current threshold?
Yeah, the current threshold.
Yes, if they have over 1,000 hours.
Right. What I'm saying is like the hypothetical that Catherine has put forward, I think already would work. Like would already get a pro bono allocation if they applied for it, right? Because all you need is basically an attorney who wants to.
That's right. And that's what I was trying to articulate and put it on an eloquent way, that hypothetical, Catherine, is like, we already had that threshold. And so that it seemed people were more comfortable. They were more fixated on the test C component of it, but maybe that was the wrong way to place like the discussion.
Yeah. Now, maybe that hypothetical shouldn't qualify even under the current test, but I'm just saying like this test doesn't allow something that the current test technically doesn't allow. It just assumed 1,000 hours was the equivalent of a substantial number of attorneys, but that's not necessarily true.
Correct.
In this moment.
So would it be helpful for Angela to go back to some of those other slides and
yeah, sure. Sorry, we've like totally,
okay.
And we should watch our time a little bit because I know we have another big one to go.
So issue number 1, whether to eliminate the substantial numbers threshold test, as we discussed, the recommendation from the working group was to eliminate the threshold test and then codify principal means test. And so you've all seen the language that was being proposed. So that's issue 1. The next issue was what to do about the principal means tests A, B, and C. So just of note, in 2023, 18 organizations received the pro bono allocation by qualifying through test A, B, or C. 5 qualified through A, 2 qualified through B only, and 11 qualified through test C only. And just for comparator's sake, in 2021, numbers were sort of similar. Same 18 organizations also received the pro bono allocation, 7 through test A, 3 through test B, and 8 through test C. So just some backstory about that. So then this brings up what to do about principal means test A. The current practice, it's just, a simple comparator of the cumulative number of pro bono attorney hours to the cumulative number of staff attorney hours. If pro bono is greater than staff, presumption is that the applicant uses more pro bono attorneys to achieve its legal aims than staff attorneys. The considerations that it's straightforward. Let's see, the community response. Numerical tests provide certainty, give applicants confidence, and minimize administrative burden was essentially the thinking from the community. And the working group recommendation was to maintain test A as is. So that's test A.
And test A before didn't require the recruitment of substantial numbers. It was just, so the recruitment of substantial numbers was part of before you got to test A, right? So what we're losing out of this is the recruitment of substantial numbers. Like if you say, what's the difference? There's no longer a requirement that you recruit substantial numbers.
Yes, the presumption is if you meet this test that you would have recruited substantial numbers.
But that could be 1.
Correct.
To be fair, that could be 1 under the current threshold test.
Well, not really. No, because you had to meet the recruit substantial number test first.
And that one of those was 1,000 attorney hours. That's it. As long as you had 1,000 attorney hours, you met the threshold test.
But we don't have any measure of what that is now. So you could recruit, it could be less than 1,000 hours, right?
That's true. I'm just saying, like, the current substantial numbers test only 2 parts of it require actual number of attorneys.
That's true. You're right.
The last one only requires hours, with the
Correct.
assumption that hours is a proxy for number of attorneys, but not necessarily true.
Right.
So just to fast forward us, since I think in this moment, that was the recommendation for the working group, was to maintain test A as is. To eliminate test principal means test B was the recommendation, and I'll just briefly go through the current practice. We don't need to go over it again, but the goals of it, of the current test B.
This is the worst. All right. This is the one that we got stuck with last time. What's the non-attorney hours?
It's sticky.
More, and yeah.
But the thinking of the current test B were to ensure, or the goals were to ensure, that a majority of service hours are provided by volunteers rather than staff, and that attorney hours provided more than half the number of service hours provided by all staff, presumably to ensure that the volunteer services are toward achieving a legal outcome. So that was the goals behind the current test B. Some considerations that the working group wrestled with are that the 2-step calculation was not intuitive, that counting only attorneys and paralegals was limiting and doesn't represent the evolved practice of legal aid, where you've got interpreters and other non-attorney volunteers who really extend the capability of attorneys. And then another consideration is that in 2023, only 2 applicants out of 18 even qualified for pro bono allocation under test B. So the community response, some suggested eliminating test B and using test C in the form that you guys have all now seen, just as a way to account for this fuller pro bono model that would include non-attorney volunteer hours. One grantee wanted to keep test B and thought it was a useful way to calibrate throughout the year and make adjustments to maintain qualifying status. Community consensus exists around whether to count non-attorney volunteers hours as part of the organization's pro bono hours, regardless of the test used. So there's consensus in the community that non-attorney volunteer hours should be counted. The working group's recommendation, and this was after a lot of wrestling with possible options. So some options that the working group considered were, keep test B as is, simplify test B into a single step, omit test B altogether. They had another option where they added a different parameter, but essentially they came down to eliminating test B and ensuring that test C is expansive enough to encompass organizations who use a pro bono model that incorporates a large number of non-attorney volunteers. Their thinking was that essentially the purpose of test B that we mentioned before could be accomplished by test C. And maybe just another point to mention, another consideration that the working group had was the revision to the State Bar Rule 3.672A that just went into effect July 1st. I'll just mention it here because this was some of their thinking, was that it revised the rule to define legal services more broadly, and they felt like this was the evolution of the pro bono allocation test was in keeping with that revised definition. So, and would it be helpful in this moment if I read to you the revised legal services rule, or you all are so familiar with it at this point?
I feel like I know it, but Erica has her hand up, so.
Okay.
I sort of just have and I'm sorry, I'm trying to, I appreciate all the stuff that you're talking about, but I'm still kind of mulling Catherine's point about the substantial number of attorneys. And I'm just curious whether the working group considered maybe making something like you have to recruit more attorneys than you have, and the number of hours have to be more. Was that ever considered? Like if you have 10 staff attorneys, you have to recruit 11 pro bono attorneys, and their hours have to be more.
I don't think that was considered. I think they wanted to make it easier, not more harder. Was the sense, more flexibility, given what Angela just said, our new definition of civil legal services, the new desire to.
Yeah, the goal was not to create more parameters, but to create more flexibility.
And I think some of the feedback is how from programs perspectives, as I read the comments, is there's also something comforting to know if you did X or Y, that would be enough, right? That having those numeric parameters is actually helpful for people that are trying to run the program and know that they have met the standard. Because the challenge with the flexibility is you don't actually know whether you did enough until you get your application submitted. And if there's a sort of more bright line litmus test, like you recruited attorneys that did X amount of work, then you know you're okay and you're not going to have a hole in your budget if you previously got the 10%. So I think it's balancing, I think, the flexibility with sort of the community's desire for some bright lines of what makes them eligible so they don't get to an eligibility and budget review conference.
Sure.
Right?
Yeah, no, I was just trying to think about, because it seems like if you recruit numbers of attorneys, that's still a bright line, right?
Yes, I agree. I'm agreeing with you, Erica.
Oh, okay. I thought you were saying.
No, I'm agreeing that having a bright line, like the minimum is like, I don't know, it's just like, that's what I'm hearing from the community comments in part of make it easy for us to know we've met the test. So we're not fretting about like we submitted and it gets elevated to the trust fund commission and they decide we're not eligible.
Yeah, sorry, Dawn, go ahead.
Yeah, and also the public comments through LAC, it's, and I think they say this outright, like they generally support it. I don't know if they love this rule. The thing is, we've been working on this for 2 years. I do think that we should move forward with something. And the big caveat that I agree with the legal aid community is like, we're in a totally different landscape in terms of pro bono work now that we are post-pandemic. They asked for the state bar staff to do a survey. We don't want the survey to delay, rolling this out. So I think that would be a longer project in terms of like, our office could do more of a study around kind of like what the landscape of pro bono is amongst our programs, or maybe a little larger. We can come back with that data in a year or two, revisit it, but we don't want to delay because the codification is such a lengthy process. And programs have asked us the last 2 years, where are you guys at in the pro bono? We want more clarity. And so I do think we're at a juncture if we can move.
Yeah, I understand.
So how do we move forward with maybe with some additional clarity of what like minimums are, right? So that, because if we pass a rule now, and then you do a great report that says it needs to be modified, it's not, this rule will be in effect for 2 years, and then it'll take another 2 years, so now we're 4 years out, right? So at least providing some interim step about like the minimum of what you'd have to do, like some numeric target, so that people that meet it know that they're not going to be in a place that they don't get the allocation because it's completely flexible and at somebody's discretion.
Elizabeth?
I just wanted to add that I think one thing that the working group grappled with is the numeric test, while it is like a bright line thing that grantees can look at to understand whether they're on the right track or not, it can be a burden for those rural programs. And so that was, I think, the tension there.
The test A, the new test A. Okay, thanks, Elizabeth. Zach and then Vanetta.
No, just really quickly seconding everything that's kind of been said about test A. I think folks like the simplicity of it, and the numerical test aspect, as everyone's saying, can be helpful so long as like there is the more expansive test C. And I think in combination seems like a good good dynamic between those two tests, I guess, to capture everyone who should be accepted.
Vanetta?
Hi. Yeah, I guess I agree with Zach in that test A seems more quantitative and then test C seems more qualitative. And so those who don't have the numbers have the opportunity to explain their circumstances sufficient enough to, to deem eligibility. So it seems to be a nice balance. B seems to, I think that accomplishes the objective without using B.
And just, I'm sure I already know the answer, but like, OGC's reviewed this. They don't have any concerns about the proposed rule meeting satisfying the statutory requirements of substantial numbers and principal means.
Yes.
They reviewed it several times.
Okay. Got it. So there's no like, we don't anticipate like a sort of legal issue. Will, you would like to make some public comment here? What's up?
Yes. I just appreciate all of the comments. Thank you for allowing me to speak. I agree, absolutely bright line. Rule is really helpful from an administrative perspective. It saves everybody money, and that's money that can go out to the public. I think that question of substantial, especially with the urban-rural divide, is very difficult. I live in a town that's in an urban county. There is one family law attorney. There's supposed to be two, but the other one doesn't answer their phone. So it's difficult to imagine that in this environment, substantial is any more than getting the one person to volunteer. So I think it is a challenging environment to come up with a rule that works for everybody. I'm surprised that like this meets substantial, but I think it works, and that I don't have a better suggestion at the moment, but I wanted to bring up the complication of really defining substantial when the county allocations are vary, the environment in each county. And I was hoping I could get a question answered, which is, we're talking about 10% of the allocation for the county. And does that mean if there was one QLSP getting money and the pro bono allocation would be irrelevant because they're getting the same amount of money regardless? Is that how the distribution works? And then where does that 10% go if no one applies for it? Just want to understand how much money we're talking about.
So if there is a county where no organization has applied for the pro bono allocation, all those funds just goes out to the existing organizations per formula. And then your other question is, if there's one grantee and they also apply, and they're the only one in the county and they apply for the pro bono allocation, I think it doesn't, I mean, if they were the only one, they would have gotten the whole allocation in the county anyways. I think the 10% would not change.
So this doesn't affect allocations year to year?
I'm sorry?
It's the same amount of money. It won't affect the allocations year to year. The county allocation, right?
No, the county allocation is calculated based on poverty, population, and qualified expenditures. And it's 10% off of that.
Okay, so this has no effect. So we're talking about for really small counties with only 4 attorneys, it would be a very small amount, the 10%, is my understanding.
Mm-hmm. Yes.
Thanks for the clarification.
Thanks. Catherine?
So is it worth thinking about, like, I appreciate the rural part and what, like, the standards currently don't work for recruiting a substantial number of attorneys, but is it worth having a standard that says you have to recruit a substantial number of attorneys, except if you're in a rural county, right? Kind of language. Because you still want your urban counties recruiting substantial numbers, right? And that piece,
I hear you. I'm not on the working group, so I'm somewhat
nor am I.
A little bit. I don't know if there's other. Angela, do you have thoughts on this?
So I think it's an interesting proposal to instead of eliminating altogether the eligibility threshold. Essentially, you're saying exempt rural counties from having to meet that.
I mean, I guess that's just in listening to this sort of, there is a difference between urban and rural. And I think the working group was trying to address that, but have a uniform standard. And I guess I'm asking, what are we losing in urban counties? Are we losing anything in urban counties that seems of value, and like knowing that they've recruited a substantial number of lawyers? which is not a standard that has ever worked for a rural county. But Jim might have a thought.
Yeah, go ahead, Jim.
I don't mean to complicate the discussion, but it's not as simple as just rural urban counties. In fact, you look at Fresno, which is classified as a urban/rural. Fresno has more rural poor in it than any other county in the state, but it has even more urban poor. So if you're just talking about the pure rural poor states, you're not talking about most of the rural poor, is my point.
Yeah.
You've also got different cultures in different counties. It is like finding hen's teeth to find a pro bono lawyer around here. So it's what does substantial mean? I mean, you're thrown back to, you're going to have to quantify it if you're going to use it as a standard, or somehow give people a clue about what it means, and it undoes the elimination of that first test. So it seems to unnecessarily, what you care about is service, and it seems the principal means test addresses the service question without, if you've got a few lawyers that are throwing themselves body and soul into pro bono, wow, more power to you. I don't know. It doesn't make any sense to me to layer on the additional substantial whatever.
Well, the substantial numbers, the recruitment of substantial numbers of attorneys is in the statute. And so that's why it's part of the calculation.
Sure. But I think to Patient's point, if OGC says that the current version of the rule satisfies the statutory requirements, why add more to it? Am I saying am I being accurate, Patience, in what you're saying?
Okay, thank you.
Yeah.
Okay, so I feel like the move now is to advance. Oh, no.
Jim?
Yeah, I just checking my email. I got another email from Todd saying he's had his hand raised. I don't know if you're chair, so if you want to introduce public comment at this point or not.
Is Shannon?
Yes, I'm here.
Okay.
And would you like me to allow him to speak?
Sure, Todd, we're happy to hear just a couple minutes though, as long as it's relevant to this topic.
Yeah, I'm actually, my commentary was relevant to the topic. I don't want to slow your topic up. I have my hand up at various points for probably almost the last hour. And as you guys communicated, for whatever reason, it's open comment. So in the future, I'm going to see, because I guess you guys really do need to move on. But in the future, please acknowledge my comment. It will be on topic. Thank you.
Okay, sorry about that. Thank you. All right, well, we've had a lot of robust discussion on this. Are we at a place where we think this is, do we want to adopt the working group's recommendation? Is there a motion to accept it? If not, is there something we want to say, some advice or something to go back?
Can we just go back to the rules so we make sure we understand,
Sure.
The memo was great and explanatory, but the rule is what we're passing and just saying, right, just seeing what the rule is, right? So.
And if I may just interject in this moment, because we haven't spoken to clarifying some definitions, non-attorney, volunteers, law students, and legal fellows. So we didn't get into that. Not that, I mean, it was all very, it was explained in the memo. So if you've read that, then you know sort of the thinking. But I did just want to specify that there's a page 2 to this rule here, right. G. So. So what do you think the move is, Erica? Is it to?
Are there any questions? Why don't you? Okay, good. You put them up. Mm-hmm. I didn't have any concerns over these definitions, but I'm curious if anyone else does. Because this is all really applicable to the to B, right? Or to the test B, really.
The new test B. Mm-hmm.
So I guess the question, in at least the memo portion, it talked about law students who were paid a nominal amount. I don't know if that's in this definition, because I was like, well, what's a nominal amount, right? Like,
and maybe it wasn't, I guess it wasn't clear in the memo, nominal amount, or like, even if they received like the Legal Services Trust Funds, like Legal Aid Leaders Fellowship, 7,500, which is like a living wage for the summer, like that, none of that would impact the ability for organizations to count law student hours as pro bono.
but what if you paid them as so what if you paid them a living wage out of your, you just paid them, you hired them?
Yeah.
Does that count or not?
So I think it would depend. The working group wanted to understand, wanted an explanation of whether the student was like volunteering. Is there a component of volunteerism to their service, or is it like they're being paid because they are, you know, they happen to be a law student, but they're, you know, like a casual hourly employee of yours that's doing a paralegal type work, for example. So that the working group has requested, as part of the justification of counting those law student hours, indicating kind of the volunteerism aspect of that law student.
But if you're being paid, like you're being paid $25 an hour as a law student, and you're working alongside lawyers on a case as a paid staff person, like you may still have a commitment to volunteerism, but you're not really acting as a volunteer. Like you're paid at kind of the rate of other people doing similar kinds of work. So I guess that's my question about, like, they have to provide an explanation, yes, to demonstrate a law student's commitment to volunteerism. I think there's some people, like, even if you said I'm fully committed to volunteerism, like I don't know how you expect that to be demonstrated then, I guess.
Then are you suggesting,
like, if you're paid to the same amount as someone else doing, like, doing equivalent job, doesn't that mean you're just a paid staff person and you're not a volunteer? Shouldn't there be a some explanation of that?
I understand that, Catherine. So I guess I'm just trying to formulate my question on how to clarify this. Is then do you think we should clarify this rule that it's not the law student's commitment to volunteerism, but it's the organization's kind of view on the law students' like participation in their organization? Right, because if I'm an organization and I have law students who we hired somebody, a law student, hired somebody who's doing paralegal type work who happens to be a law student, and they're, working part-time or whatever, and they're being treated as an employee, I wouldn't count those hours as pro bono. But if I have a summer law student who we're paying something, maybe not equivalent to a paralegal in our office, but we're paying something that's not nominal, there is a component of volunteerism from the view of the organization.
Can I ask a question?
Sure.
We've at CCLS, we had summer students, interns who had a stipend, and they were with the housing team, or they were with the family team, or whatever, but they volunteered, not part of their assignment, not part of what they had come to us to do, but they did multiple immigration clinics, or they did tax clinics for folks to apply for earned income tax credits. I mean, in other words, they stepped outside of what it was we had asked them to do. They were putting in hours that weren't technically part of their internship assignment. I mean, that seems to me the kind of thing that student volunteers might end up doing. It's not what the kind of work they're providing isn't in consideration of the stipend that they are receiving. That might be too complicated a standard, but.
Okay. Yeah, that's a fair point. Let me let Heidi and Shannon also talk.
Yeah, the one thing, the example that I would give for this purpose from my prior experience was we would have law schools that wanted to play, in my prior organization, they had law students who wanted to place their students with our organization, but they required us to hire them and they reimbursed us for it so that they would show as a paid person on the organization's payroll. But the only reason we would pay them was because we were being reimbursed by a third party. So it was kind of a catch-22 where the prior organization I worked for, who was a pro bono program, would have to make a determination about how that would impact our allocation or our numbers, because they were paid, but they were really only paid because we were being reimbursed by a third party to have them on our payroll. So that would be an example, I would think, where you would have a paid law student who the real purpose is a volunteer sort of thing coming from a third party sponsorship.
Thanks, Heidi. Shannon?
Yes, we have another public comment request.
Okay. Do we know who it is?
This is Todd Hill. I am allowing them to speak.
Okay, Mr. Hill. Is this relevant? I'm happy to have you do one more comment, and then I think we're gonna, as long as it's relevant to the topic, and then I think we're gonna move into whether we're gonna move on the motion. Go ahead, Mr. Hill.
Thank you very much. I appreciate your reticence, I guess. So as I've provided you earlier today, I submitted to you 2 logs for clinicals that I took as a student. And so from my perspective, this topic is about, there's a student protection aspect here because you're awarding money, and you could be awarding money for places that are actually engaged in questionable, there's still an open question of conduct, right? And so from that perspective, I've got 2 very copious logs. The logs were required by the institution, right? As I mentioned earlier, I don't have a transcript. I wasn't paid, so I don't have proof of the work, except that I've taken the logs and associated with those logs, there actually is a very nice record of me submitting the logs weekly to the professor who are the instructors who are listed in actually the logs themselves. So from my perspective, I just wanted to bring up that there is actually an even more interesting aspect, because again, under current State Bar policy, the State Bar does not intervene in conflicts between students and their institutions. And so an institution can come up with a scheme that really does take advantage of that. Thank you.
Thanks. Yeah, I mean, I think to that point, so
maybe it's just as simple, Erica, is saying like how the program has determined that they're volunteering. It's not really about a commitment. It's like the program has to decide, are you a volunteer or not a volunteer? And what's the basis upon which you decided they're a volunteer?
Okay.
Excuse me, there's one more public comment.
Oh, okay. From Mr. Hill?
No, it's from someone else.
Okay.
I'm allowing them to speak now.
Okay. Who is this?
This is Betty.
Okay.
You know, I've run a pro bono program and we're very grateful for it. And I appreciate all your time, and everything you've talked about has so many ramifications. I just want to tell you that even the Law Student Fellowship this summer, you know, even has questions. First of all, we hire students for the summer to do work. I don't know how you asked me to decide whether that's volunteer. We're expecting them to do work for the summer. They are expecting to have this on the resume as the beginning of their resume building. So to say to me next summer, we have to decide whether, you know, there's some myth of them being volunteers. Are they more than volunteers? Yeah. Yeah, we put a week of training into them. We're giving them pretty serious caseloads. So, you know, even, and is the 7,500 nominal? I don't know, compared to 140, or some of the students who are working in private firms are getting 40,000 for the summer. So yes, 7,500 is nominal. Some of them got more than 7,500 because they got a second grant from somewhere else. So we found out later on that some people were getting really 10,000 for the summer, but again, compared to 40,000. So you're asking, you're making it, I do want to say, in some sense, more difficult, you know. So it would be nice to have a nice, clean rule that says if you've got law students and they are doing, you know, full-time work or something like that, then they, you know, you can still consider them volunteers. You know, I'm just saying it's difficult. And I'll tell you, there's a really thin line between D and E, because we've had law fellows from Columbia University, UCLA, all of whom are getting what I consider very nominal salaries, like 10,000, 15,000 for the year. And, you know, I think those are as nominal as D is, and you're telling me that E, I have to call staff, and D, I can somehow make up a fiction that even though we consider them pretty serious workers for the summer, they're really volunteers.
All right. Thank you, Ms. Nordwin. I guess I just have one quick question, which, Angela, I don't know if you can answer this. Sorry, is what's the reasoning behind the law students? Why are paid law students considered volunteer hours? I just don't know if there's like a policy reason.
If you don't mind, if I go back to, because you guys didn't have the benefit of us going through all this, but the they support programs across the state. They maybe for a summer or a semester. They're supervised by attorneys trained in the organization services, legal subject matters. So essentially, I guess what I want to speak to is that there is definitely a tension that's obvious between wanting to recognize volunteerism, but also ensure that there's the pipeline and where
right. So it's a recruitment and retention issue, Erica.
Right. Yeah, it's a policy.
So we want to encourage our grantees to pay law students because it's both a recruitment and retention issue and it's a diversity, equity, and inclusion issue. So we want to encourage that, but we also didn't want to penalize our existing programs who qualify for the pro bono allocation due in large part to the number of hours that their law students provide.
Got it. And again, OGC doesn't have a problem with paid law students.
No.
Coming in as pro bono?
No.
All right. Okay. I guess my view.
So then isn't the simpler view then just to say all law students are volunteers? Like then I don't see any distinction.
Yeah. Is there?
Well, I think it's the working group did want to distinguish the law student, the person you've hired who's doing paralegal type work, who happens to be a law student that's being paid like a wage that's similar to like other paralegals at your organization.
But then we should say that more clearly, I think, because this language to me that gets confusing is demonstrated a law student's commitment to volunteerism, right? So if you're being paid equivalent and doing the same work as other staff, you're not a volunteer, is what I hear you saying. Yeah. But if you're paid as a law student and you're sort of getting experience, but you're not doing the same work as other staff, then I just think we have to be, to me,
so maybe I felt like the language being paid kind of equivalent to other staff and doing like work similar to other staff. I think that concept might be translatable into the role.
Yeah. Maybe we can do something like it seems like this would be easy for programs to be like, you're either an employee, like your job title is paralegal or your job title is law student intern. And if you're a law student intern, then you're non-attorney volunteer hours. And if you're a paralegal, you're not. regardless of whether they're in law school.
Don't
no?
use the term intern because it has all kinds of.
Well, okay, sorry, fellow, whatever. I'm just trying to say, like, you could have a job title.
I just think it's like, are you paid to do the equivalent work, paid the same and doing the equivalent work of other staff, right?
Yes.
Whether you call them a paralegal or something else. You could be a community outreach worker. You could be a somebody else, right?
Mm-hmm.
I'm trying to be cognizant of time because, like I said, my understanding is that there's sort of a push.
For me, I've already made arrangements to stay where I am, so I have less of a problem.
Okay. So I guess my question is, at this point, is it like with that change, right? Is it that is the sort of sense that like we should send this back and then it should come in October with this language, or can we make these changes on the fly and then approve it? That's my question.
And do we need to do a similar thing for legal fellows? That's sort of what Betty was raising, that like, I'm not sure what the legal fellow rule is.
That one, it counts as staff attorney hours, even if they're paid by a third party.
So that seems fine.
Yeah.
Because they're law school grads, right?
Yes.
Yeah, law grads.
I could, in this moment, pull up just a draft of the rule language if you wanted to do a couple red lines. Okay. So
yeah, maybe we can stick it in like Word or something and then see if we can make the changes we need and then.
Erica, Ms. Norwood has her hand raised.
Oh, sorry. Yes, Ms. Nordwin.
You can speak now.
That's a mistake, sorry.
Oh, okay. Thank you. Thanks, Shannon. You've been quite on the ball today with this.
So my hope is everyone can see this rule language. Is that true?
Yes.
Okay.
So why don't we start with the definition, since that's one I think we're all relatively in agreement on. So down to GD.
And it's here, right?
I think it's just law student hours count toward volunteer non-attorney hours so long as they are not being paid for work equivalent to other employees. Does that sound right, Catherine? Is that kind of what you're envisioning?
Sure. I think they're paid an equivalent amount and doing equivalent work. So you don't, I don't want to have somebody paid less and doing the same work.
Yeah, fair enough. Yeah.
Work as a paid employee.
Yes. Great. And then I think you can just take out the rest of it, because it doesn't matter as long as their hours. Okay, because I'm in agreement. We want to encourage. Okay.
But do we want? Do we want to leave the academic credit in, just to be clear? That like if a student is, at your organization and they receive academic credit, that would count as pro bono.
Oh yeah, I was interpreting it to mean like any law student hour counts towards volunteer, no matter what.
Okay.
So long as they're not being paid.
Okay.
Equivalent to an employee, to kind of get the paralegal problem.
Sure. Okay.
Okay. Yeah.
Okay. And then the other
one we had was, I think we need to say must show.
Right, must show that it recruited substantial numbers.
Because then it says it has to be one of these two tests.
Yeah, and I think in the memo we need to kind of elaborate so that it's like crystal clear kind of how it works.
You mean as far as going to one or the other test?
So I guess, I mean, maybe this is the solution, that they must show that it recruited substantial numbers of attorney in private practice. Is that something they have to separately show then? Or it's only they show it by
meeting.
So they must show substantial numbers and principal means through A or B.
Yeah, not separate. It's and, right? So they must show it recruited substantial numbers and that the pro bono is the principal means through one. So that's how I just want to be clear, because if we change it and we understand that you have to show that you recruited a substantial number of lawyers, however you're going to show that, it's not like a number, a percent or anything else. And then the and that pro bono is the applicant principal means through one of the A and B, then that's clear to me.
So you want essentially the substantial numbers to be a different, to not be met through A or B.
I mean, that's how I read what the change is saying, because may doesn't make any sense there, right? So because right now it would say they may show that it recruited substantial numbers of attorneys in private practice, and that it's like, so what's the point of may show that you have recruited substantial numbers?
I think the way it's supposed to be structured is that the way you show both things is you meet A or you meet B. And then if you show A or B, you meet both substantial numbers and principal means.
Yeah, I just don't read it that way. So that was way back when was my question.
So I guess the question is, do you think if we reword it so that you can meet substantial numbers and your principal means by A or B, are you in agreement with that? Or are
does the statute, it says does the statute talk about recruitment, or what does the statute say?
It says substantial numbers, but Brady and OGC has said that this test as structured satisfies it.
That the statute says recruited substantial numbers?
The statute says the coordination of the recruitment of substantial numbers of attorneys.
I guess I think of that statute as having a test about recruitment, and so I can have a different opinion than Brady, and it doesn't mean I'm not trying to say I'm right. It just,
I mean, we can run it if it's a sticking point.
Yeah.
We can run it through Brady again. We can go back and workshop. We can whatever you want.
Yeah, we can go back to the working group as well. I mean, you don't have to feel pressured to.
Yeah. Because I think our difficulty today is the working group members aren't here. I think the staff members are struggling. I think we think we're not. We hesitate to speak so much on their behalf with so many hypotheticals. So if you would like us to go back and to the working group members.
Got it. I guess it sounds like, I just am trying to make sure that Catherine, you feel like as currently structured, if you can meet both substantial means or substantial number and principal means through A, that is a problem. You don't think that satisfies the substantial number.
I just think there's still that you have to show through a non-numeric way that you recruited substantial numbers, and through A and B that you've demonstrated this is your primary means of delivering, right? So I'm not in any way saying that I want to go back to the first test that said it had to be 5% or any of those things, but it feels like you should, consistent with the statute, say you recruited substantial numbers and this is how you did it, which in some ways is covered under C, but I think that standard's going to it's your primary means, not to your recruitment and retention of people.
Okay. Well, is there any other opposing views or other thoughts on this from the other committee members? I want to make sure if everyone's like, if there's an overwhelming, like, actually, we love the rule as is, we should vote on it. I want to make sure we're not calling that, but otherwise it sounds like maybe there's a little bit of workshopping to do on the substantial numbers piece. I don't read the stat from what I saw from the memo and my understanding of what we discussed today. I don't read that the proposed rule is saying substantial numbers and then principal means through A or B. And I'm a little worried about doing substantial numbers without a bright line rule like that. Those sort of the benefit of A.
I mean, there's kind of no bright line rule except for maybe A, which is still not really a bright line because, you just have to have one more hour than your staff attorneys have, right?
Fair. Yeah, Dawn, what's up?
What I'm hearing is, there's a high level of discussion. There's still confusion. So I would like to move this forward, but I don't think we should. I think what we should do is go back to the working group, workshop a little bit more, and then bring it back to a rules committee, not send it to the commission. I think it does warrant a little bit more discussion and clarity. I think we probably need to work on the rule itself too, so it's crystal clear.
Okay. Thank you for answering all our questions. Angela, thank you for going through the gauntlet of the rules committee and all of our strong opinions on how we get this done. All right, let's move on to the next beast, the first of the fiscal stuff. So Heidi, you're up.
Actually, I think Crystal's going to kick us off, and I will share my screen.
I'm sorry, Crystal. I apologize.
Oh, no worries.
I made an assumption and I should have looked at my annotated agenda.
Well, the good news is Patience is a member of this part of the working group, so she can help inform our thinking.
As is Erica, so hopefully we'll get perspectives.
You're
yes.
right.
All right, good afternoon. So I'll be co-presenting with Heidi on item 4.2, the recommendations regarding 4 fiscal codification related issues. We can move on to the next slide. Also, I was just sorry, forgot to notice as well, in addition to Patience and Erica, Jason also serves on the working group. We're going to try and condense our presentation just so we can get hopefully major points. We have 4 subtopics to discuss today. But just briefly, our agenda is that we'll give a preview of the fiscal codification work plan, talk about the topics and recommendations for today's meeting, have some discussion, and hopefully get to a proposed resolution. Next slide. All right, so here on the screen, we'll leave this up for a little bit, is just a really high-level overview of the Fiscal Codification Working Group's work plan. As you can see, there's a lot of complex issues with implications on administrative processes and maybe some other proposed rules. After initial discussion, the working group determined it'd be most efficient to take a bifurcated approach that further categorizes these issues as either warranting a rule change, which you see on the screen, or whether it be an administrative process that needs clarification. Essentially, issues with potential implications for eligibility or grant compliance have been identified as appropriate for the codification process. Also, as a note for this work plan, the working group recommends that those administrative processes be captured in document in a separate grantee handbook. This handbook would be a complementary resource for all state bar rules, providing administrative guidance for how the rules would be implemented. Unlike the rules, the grantee handbook would be more flexible and subject to change on a more frequent basis. As you can see, there's 5 main buckets, but this is a very complex, complicated work plan. Working group has been working on discussing these items since early next year, and it's currently projected to hopefully be completed in 2025. Preliminary recommendations will be shared both with the legal aid community and the rules committee on a rolling basis, such as today. Next slide. All right, so the 4 subtopics that we'll be discussing under eligibility issues are audited financial statements and financial review findings, how to address findings identified by an independent certified public content in either of those documents, talking about criteria needed for payment and or delay payment of grant funds, what criteria are needed for implementing and processing grant award reductions or grant terminations, as well as providing some definitions and developing a formal process for redistributing unspent and relinquished grant funds. So to give an overview of how each subtopic will be discussed, because there are 4 rules that the working group is proposing, we're going to be talking about each subtopic and each proposed rule sort of individually. So we'll go through all of them with the working group considerations, the recommendation, a high-level summary of the legal aid community feedback, and as well as responses to that. And then Heidi will share a screen of the proposed rule, just so if you need to make edits or have any feedback, we can capture that in live time. So the first subtopic for discussion are audited financial statement and financial review findings. A couple of main considerations. According to State Bar Rule 3.680E1, all applicants are required to either submit an audited financial statement or financial review by an independent certified public accountant as part of the IOLTA EAF application process. Currently, in terms of current office practice, there's actually no guidance on how to address these findings that are identified. The working group's recommendation is to create and implement a rule that outlines a process for certain findings. There was some distinction and also some feedback in terms of what these findings would encapsulate or require oversight, which I believe is reflected in the proposed rule. Also, another feature of this rule is that the Commission may require some additional correction or follow-up as outlined in the rule. Okay, next slide. A couple of comments specific regarding this proposed rule. The community wanted to know how widespread audit findings were amongst grantees. They also wanted to get clarification on whether the Commission would be concerned with all audit findings. I think one point that was brought up was that sometimes audits are a good tool for organizations to help improve infrastructure and things like that. So they wanted to make the distinction that those types of findings wouldn't necessarily be brought for Commission oversight. So therefore, the community suggested distinguishing between serious and minor findings in the feedback, and then there were concerns over some open-ended language, both in the rule and in the analysis or the rationale for the rule. And then there was some comment about potentially the rule being a blanket rule. The response to the feedback, I think as a point of clarification, although audit findings are not a widespread issue, because when they do occur, there is no guidance or past office practice. The working group felt it was important to create a rule to provide that guidance if in the situation that were to occur. We also try to address the open-ended language concern by conveying examples in the proposed rule. Also deleted single audit finding in efforts again to narrow the scope of audit findings that would be elevated to the Commission. I think finally, one point home is because audits are a critical part of determining IOLTA and EAF eligibility, the working group felt that it was important to create a rule to create appropriate Commission oversight over this aspect of the application. So Heidi, if you want to share the proposed rules, or happy to entertain any questions. Oh, I see Catherine's hand up.
I just have one question. So help me understand how elimination of the word single audit narrows the scope as opposed to expands it. So single audit, I think, is what happens once you get federal grants and there's specific requirements about what the thresholds are, right? So by removing it, doesn't it make it more likely that there's more people that would be covered by the rule rather than narrowing it? So I guess I'm just trying to understand, maybe just help me understand how the phrase single audit, it said it narrowed it, and I'm just trying to understand how it narrowed it.
Yeah, so I'll take a stab, and then Heidi and then any of the working group members on here. So the actual proposed rule had the terminology single audit finding. Upon discussion and I think feedback from the working group and community, I think there's some striation in what a single audit finding was. So I think that felt too, I don't know if it's restricted, like I know we're talking about restrictive versus narrow, but we didn't want to just say all single audit findings would be elevated because we'd have to look into the context and the type of finding. Dawn.
Yeah, I think the idea was like we would elevate findings, whether it's from a single audit or a regular audit. So that's why we eliminated the distinction with single audit finding, because before it could have been read at any like Crystal was saying, any finding from a single audit. So we kind of eliminated that distinction. It really is any serious finding from an audit, right? That we receive.
Okay, that's clear. Thank you.
Great. Shall we take a look at the proposed rule altogether? Sorry, Heidi, don't mean to put you in the spot.
Is it not showing on the screen? Oh, all right, hold on. Try again. I thought I had it. Now is it there?
Yes, thank you. If you can scroll down a little bit, I think for everybody. Yeah, so this is the full proposed rule. I don't think there's more to screen below it. I think just to note, this grantees is in track changes. I think just in efforts to sort of tie in the terms consistently, that was one change made after this agenda item was posted. So I'm not sure how long we should hold for any comments. I know we have 3 other subtopics to get to. I'm not hearing some immediate thoughts, or do we want a few more moments to take a look at the proposed rule language?
Okay, so this just says send a letter to asking for, so the staff can send a letter, right? So the staff looks at this, they review it, they fact determine it's significant. They can send a letter to the grant recipient's governing board requesting the status of the finding. If it's not resolved, require a corrective action plan, right? And then they always notify the commission of any significant finding, or only if it's not resolved under number 1.
I think we anticipated that they would always notify the commission if there was one of these serious findings, so that the commission was aware, even if the finding was resolved. I think the idea was that the commission had an interest in knowing kind of what the status was. And then obviously we would expect the staff to provide the information about the resolution as well.
And we don't need to say, like the second part of what you said, Erica, notify the commission and provide the staff's recommendation or the staff's findings or anything, or that will just happen on the natural.
I think it'll happen somewhat naturally, but also I think, as Crystal flagged, we sort of anticipate kind of a handbook that will accompany the formal rules that will put in things that are more like practices that we anticipate following. That guidance will be public, so it won't be sort of something that anyone will, we want to be transparent with it, but we think some of those things might be easier to kind of keep in an administrative manual rather than have everything in the rule, when we might want to have some flexibility on some of those practices. Crystal, I think you might be okay to move forward. Thank you.
Okay, wonderful. So I'll now hand it off to Heidi, who'll talk about the 3 remaining subtopics.
Should we do these one at a time? And what we're doing is recommending to the commission as a whole that the commission adopt these. So I'm moving the proposed rule attachment A, that this body move it forward to the August 10th commission meeting for approval.
Okay, Crystal, is that okay? Any issues if we do them one at a time?
Want any issues with that? Okay. Okay.
I think that's a good way to do it. If this way, if there's issues, we've at least cleared. I'll second.
Okay, I'll do roll call. Al-Sarraf, Fightmaster.
Yes.
Blakemore.
Yes.
Boschelli, Campbell.
Yes.
Culkin, Meeker.
Yes.
Milrod.
Yes.
Connolly.
Yes.
Motion passes.
All right, we got one done. Good job, Crystal working group. We only have like 2 more years to go. All right. Thanks, Crystal. Ready for the next one. Or Heidi. Heidi's now taking it. Thank you. Go ahead.
I'll be the next person on the chopping block. So the next rule for us to review is the delayed payment of grant funds. So get this. So the starting point for this was there currently is not a mechanism for how to handle ongoing grant payments when a grantee demonstrates or reports a significant underspending and or performance issue along the way. And one of the things that the working group talked about was that if there were spending thresholds established as part of the grant making process, that this could reinforce the expectation regarding grant expenditures and conditions for receiving some subsequent grant payments. There is one thing to note that the statute does provide when there are questions about performances that a requirement to convert to monthly payments. So we can't stop payments in their entirety, but we can, the statute does allow for converting to a monthly payment schedule. So the working group recommended that the commission require that a grantee meet spending requirements before receiving subsequent grant distribution, or sort of allowing for that process to exist in future grant making endeavors. And then in the absence of established spending thresholds, staff may convert grant payments to monthly payments under certain circumstances as outlined in the proposed rule. The commission would be notified in the event of a change in the payment schedule, and then the commission would determine if conditions needed to be met before returning to the original payment schedule. So the feedback from the legal aid community focused a lot on whether or not the actual grant recipient would be able to participate in the conversation regarding delayed payments, and asked for clarification of sort of open-ended terms like failure to comply with grant requirements. And so the working group went back to the rule, and they added paragraph 4 to the proposed rule, specifying that the changes are subject to reconsideration of the process as outlined in Rule 3.691, and also acknowledge that Rule 3.691 currently is intended for the denial and termination of funding, but the reconsideration process as outlined would be applicable for the delayed grant funds. And the intention is to go back and revisit 3.691 to expand the topics that it considers, but that the reconsideration process wouldn't be applicable for this situation. And then to provide more clarity, failure to comply with grant requirements was changed or deleted, and additional examples were added to paragraph 2. So to kind of clarify under what circumstances this rule would kick in. So I'll go ahead and put the rule itself on the screen because it's easier to read in a Word document. And so this is the proposed rule as the working group has drafted it. I'll give everybody an opportunity to read it on the screen and ask any questions or provide any feedback. And I see Catherine has a hand raised.
So I guess a couple of questions. We're sort of being asked to pass a rule without understanding what the spending thresholds would be. Right. So when do the spending thresholds get set?
So this would, the intent or the idea behind the spending thresholds is that they would be established at the RFP process. So it would be included in the RFP for a competitive grant process. So that, like, say in a multi-year grant, for example, you would have to have spent, X percentage of your grant in that first year before you get the second year and third year and fourth year, et cetera. So it would be known at the beginning of a grant process. So obviously this would not apply to any of our existing grants right now, but that would be something that the commission could put into the RFP process. And
so then it's only for competitive grants that this applies to, not because I didn't see that limitation anywhere.
Most likely that is how it would be applied. I think that is the concern, this has come up where there have been grantees who have had multi-year grants, whether they be formula grants or competitive grants. So the one example was a formula grant, but it was a multi-year grant. So I think it'd be more of a multi-year issue as opposed to a single year issue.
I don't know. I mean, I feel like, is this applying to IOLTA or equal access grants or not?
Well, it's just the commission may require. So it would be up to the commission to determine whether or not. We envisioned it happening more in a multi-year environment than a EAF or IOLTA
I just feel like there should be clarity, and there's like, so for example, I guess here's my worry. I'll just be clear about my worry. So you get a big increase in your IOLTA grant, and the only way you're going to be able to implement that is by hiring a lot of staff, and that's not going to happen until month 7. But if the spending thresholds were that you had to spend X percentage of your grant, 25% of your grant in the first quarter, and if you didn't, you're going to, be in this other category. I think that puts programs not in a great place. I mean, like, it takes time to get things up and going, and particularly when there's sort of big changes. And so this seemingly gives sort of this complete discretion for some future time that the commission could set thresholds, but we're establishing what the rules are. And then I guess my second concern is the remedy, so to speak, is a reconsideration as opposed to kind of the discussion at the front end about why aren't you spending it? What's your plan? All of those kinds of things. Because I find reconsideration's fine, but I think it's better to work with a program at the front end, not just to say your remedy is a reconsideration.
Yeah, Jim, go ahead.
Yeah, similar type question. It seems to me that this would really only apply to multi-year grants as opposed to your typical yearly grants. Is that so? And how would this factor in, say, like federal grants, like the HP3 grants, which were basically from the feds, which required quarterly reports as opposed to yearly reports?
Well, the quarterly reports or yearly, when you have yearly reports, it makes this a harder process to put into place because the reporting period and the paying periods are in conflict with each other. And so that's an issue that hasn't been resolved and will probably be addressed later down as we talk about expenditures and expenditure reporting further down the road in our fiscal codification process. So I do think that the focus of this rule does lend itself more to multi-year grant environments, and that being a more applicable place, and that's being sort of more in keeping with where we've seen issues related to this kind of disconnect between the money going out and the money being spent.
Yeah, being chair of the Homeless Prevention Committee, and we had a grantee that had a 3-year grant, didn't spend anything in the first year, wasn't spending anything in the second year. And there are current established procedures, which are really set up for 1-year grants, had a hard time dealing with that. So I see the merit in this. It's important, but perhaps maybe it should be delineated that this is really geared at multi-year grants and not for the typical yearly grant. And given the current state of things, I don't see the feds giving us multi-year grants in the near future at all, personally.
Well, I mean, yeah, federal grants get a little complicated, and that's and so we prepay our grants, and so we give money up front, whereas federal grants, the preference is you do reimbursement grants. So that isn't how we've administered our federal grants. So we are giving it up front, and so that does create a little tension with the ability to do the federal grant oversight the way it's normally structured for federal grants. And so part of part of sort of the impetus of this is grantees, where we do know that there is a problem, that they're having challenges spending money, but yet still having to send out another third of their grant when we know what they're sitting on a full year's worth of expenditures that haven't gone out. And so part of it is, and in the example Catherine gave before, where they're trying to ramp up, you wouldn't have those expenditures necessarily going out. So not having the money up front, there isn't an expenditure tied to that until the 7th month. So that could potentially, it isn't that they need the money because they're not spending the money. So
but it's who keeps the money, I guess, right? I mean, because the bar has to keep it, right? If you're not going to give it back to the grantee. And would this apply to then, so multi-year grant. I don't know how you're going to consider future, like the proposal is that IOLTA could be spent over a multi-year period, maybe as long as 4 years. So does this mean that would now change the methodology by which programs are receiving IOLTA grants if they select multi-year budgeting?
No, I don't think we're allowed to change the disbursement for the IOLTA grant because there is a requirement that the disbursement go out annually. So if for example, next year we allow grantees to spend that over 4 years, they're still going to get the full year in the quarterly payments. We're not anticipating.
So can we then just change this to say for multi-year with some definitions so it's clear to programs what grants fall within this?
Sure. Is it
grants to RFPs? It seems like what you're talking about. Like it's
I don't know if anybody else on the working group wants to chime in on this topic. I know there are other questions are raised.
So I have a hand raised. Hello. Our discussion at the working group was centered around issues that had already arisen. This didn't come up in a vacuum. This is based on, and everybody was extremely discreet. So I don't know exactly what program and I don't know the details, but it has been a problem that payments have continued to go out on a regular basis when they're not being spent or they're being misused or whatever. So the spending threshold, I just went back and looked at my notes from the meeting. I don't remember that we really discussed this at the level that this is being considered right now. What we did say was we're going to be in close communication with the working group that's looking at carryovers and budget modifications. And that might be, this threshold question is actually an additional issue. As Catherine, as you say, it's a prospective. It hasn't arisen yet. But the issue, the paragraph 2 is designed to address a thing that's really happened, like apparently more than once, and there needs to be a mechanism for addressing it. So it seems that this rule isn't ready for prime time in the sense that it's ready to be, people feel comfortable adopting it as is, but I wonder if we can peel off the spending threshold question and address that with the budget modifications and carryover working group, and then and adopt the rest of it without.
But doesn't number two is written could apply to any grant the trust fund program administers, including IOLTA or EAF.
And I would defer to staff to help us understand whether that's necessary. It wasn't my recollection that the problem arose only.
There's like statutory discretion, like the statute actually permits to, in a way. So that authority under 2 is not something that we drafted kind of whole cloth. The statute actually provides that the commission is allowed to move to a month-to-month payment schedule if there is, I think, failure to meet certain grant requirements. So that's what we're trying to do is put in here what the factors are that we will consider if we were going to move into that. And then there's another rule that provides how if you move to month, what the reconsideration, and then you go to state bar court.
Yeah, so I appreciate if there's, it's just like underspending in this. I don't know what that means. And for purposes of administering programs, like if I'm underspending, is it I'm underspending by 10%, I'm underspending by 25%, I'm underspending by, like, those things actually matter. And that is the one that makes me the most nervous. I also feel like there has to sort of be a process by which you like indicate there's fraud and some ability to kind of quickly resolve that, including having discussions with programs at the front end. I mean, I don't think these things come, it feels like I am aware of one circumstance where a program was underspending its grant. And so I'll assume it happened a limited number of other times, but it's not like something that happens all the time either.
So what we discussed was using the LSE 25% metric. Again, remember this rule is accompanied by implementing guidelines, and there's a question about whether we want to set in amber some quantified amount of underspending in the rule. But I guess you should have seen it the way it was originally written. It's like, yeah, we can do this for any reason. So we thought we were doing pretty good, like limiting discretion to certain specific identifiable sins of omission.
So were there findings before? Like, how did the findings?
Wait, let me finish.
Okay,
It was also a concern to me that this not be a like, hey, we're lowering the boom and you can reconsider. And I can't remember. Erica was the one that reminded us that there's already a process, but the process, it's an interactive process for sorting this kind of thing out. I agree with you, Catherine. This is not the kind of thing that, all of a sudden we land with both boots on a program. There should be a conversation like, what the heck is going on here?
Right, but the rule reads that way, right?
Yeah. So one thing we've sort of toyed with, and I sort of knew this was going to come up as an issue. So I'm sort of laughing to myself, is like, one thing we thought about is like trying to have some kind of due process type of like rule that's like separate, so that we don't have to put it in every single one, right? That we just cross-reference to. So we're like, anytime we're going to have this kind of a decision, you're going to go into this procedure, right? And so here's how it's going to go. We're going to send you notice. You're going to have an opportunity to respond. There's going to be a certain timeline. So, and Heidi, correct me if I'm wrong. Did we talk about like, I think this is one that we would benefit from, that kind of a cross-reference, or I can't recall whether the statute or the other rule already lays that out and we can just cross-reference to it. I think this rule 3.691 might be it.
I think it, yes. And yes, that was the intention, is that there is a mechanism in there that sort of allows that back and forth.
Instead of reconsideration, I can't remember, does the rule anticipate that it could go there before we switch to it?
I'd have to, I know the word reconsideration is in the rule itself, and that's why that's the word we're using here. Let me
look at the rule, and
then I can pull it up.
Will, you have a comment?
So as part of our complaints process, which referenced 3.691, I reviewed the statute. And so it's business and professions 6224. And I would tend to think of delaying funding as termination. You're really upsetting the planning and operations of an organization. And in that way, I would say 6224, where it says pending final determination of any hearing held with reference to the termination of funding, financial assistance shall be continued at its existing level on a month-to-month basis. So any rule, I feel, that is going to upset their planned operations without giving them notice, and that's what it says, the line before that, they should be afforded reasonable notice and an opportunity for a timely and fair hearing. I think that all has to happen whether it's a delay or a termination. I think they are functionally equivalent, and it's really important to observe those requirements, not just because of the statute, but also because it helps programs plan and get a fair shake.
But how are who's making the decision that there has been indications of fraud? Doesn't mean there's a finding of fraud, right? There's an indication of fraud. Or what is organizational mismanagement? Then we have the significant underspending. We have accounting irregularities, misuse of funds, like failure to meet deliverables, right? So somebody, who's making those determinations? Is it the staff? Is it the commission? How is that decided? How is the program engaged? So like before you decide you're going to take this action, how is any of that decided?
Well, I think it would be an interactive process with staff in the program. So the staff would not take this step without having some reasonable reason to proceed this way. And the examples that we've had in the past where, you know, the staff did not have a mechanism to say, you know, hey, you've not spent 2 years of funding, we're going to send you a third. Or in another example, an organization was saying, hey, we know we're not going to spend this, but hey, we're going to send you out a very large check in 3 days. You know, we haven't had a mechanism for that. So I think if we could add to that section 2, perhaps, you know, sort of a level of communication and interaction with, and the sort of the intent is that step 2 is a temporary process until it gets then elevated to the commission. And then the commission would make that final determination going forward. So it gets
elevated before the funding is changed, or the commission is the reconsideration step? So
I think the staff could temporarily just issue 1 monthly payment, you know, or convert to monthly payments instead of sending out a full year's worth of payments. And then it would, at the next opportunity that the commission could hear it, then it would go before the commission to determine whether or not that monthly procedure would continue or convert back to the full payment of the funds.
Which is why the delay is not equivalent to a denial. Because monthly payments would continue to be remitted, even though the whole big check is not landing.
But it's monthly payments based on, so use my example. So you were gonna hire staff, but you're on a monthly payment. Now you've staffed up. So is it based on your expenditures for the prior month? It's based on 1/12, which may or may not be, like there's just a lot of, like, to me, the nuances here actually matter and what the process is. So that the terms matter. Like I wouldn't even know what to do of like indications of fraud. Like they just seem very broad. And it seems like you could end up in a place where the program didn't have, like it becomes kind of a death spiral because you don't now have the money to operate because it isn't clear, like, are you being reimbursed for the prior month's expenditures? Are you getting a 1/12 of your grant? Or like what is, there's just details I think that matter that to me should be spelled out in a rule, not in a manual that accompanies it. Because to me, it's serious. I mean, it's serious what the program might be doing, and it's serious what the consequence is.
Okay, I hear ya. So it sounds like the feedback is, one is whether spending thresholds should apply only to multi-year and or competitive versus all grant distributions, and potentially what a little more detail on like how that would be determined and implemented. And then second is if we're going to what exactly is the degree of evidence and the standard by which we will decide that grant payments need to be shifted to a monthly basis, and what kind of procedural mechanisms will be in place, such as notice, opportunity to respond, and then a determination, if necessary, to move to that month-to-month determination. And then the one thing I will just say is like what 6224 anticipates, and what we sort of anticipated with this rule, and I don't want to like lose this as we go back, is that this is supposed to be, an emergency kind of mechanism, sort of like a preliminary injunction, right? A TRO. We have evidence that something very significant is going to happen, and we have significant concerns about our money going out to an individual that has those. Now, I will acknowledge that in a TRO, everyone gets an opportunity, right? But we want this to be an expeditious initial process to switch to month to month, with the expectation that there might be a final determination in which it all goes back, or you reach, a certain negotiation. So I think if everyone, unless anyone has sort of significant objections, I would like to model it that way, as if it's sort of a TRO type of thing. So everyone gets an opportunity to have their say, but it's quick, right? Because what we don't want is to send a ton of money out if we think, for example, there's indications of fraud. I understand the significant underspending is not as nefarious as like misuse of funds or accounting irregularities. And we may need to like tease that one out a little bit more and maybe think about whether that's warranted for a TRO or whether it's warranted for something slightly different treatment. But does that structure kind of make sense?
Yeah, so, and I think framing it the way you did, which is there are significant, whatever you're going to call this group of things that rise to that level, that require emergency action, right? Or short action, right. So if the intention is to respond to an emergency, something that requires that, and there's sort of no other way to resolve it, right? So, I think that's fine, but I think there's some gradation here about, right? And there has to be an opportunity. I think there has to be an opportunity for the program to get a letter that says you need to respond in 10 days to this because this is what we think happened, and have the opportunity before you change it to say, no, you're wrong. Here's why you misunderstood that, or whatever it's going to be.
Yeah. Yeah. And I understand that, I come from white collar defense work, and the worst is when the FBI just calls to be like, there's a problem, right? And then you're suddenly like, our check is about to go out the door, right? So you want to have some ability, right? God willing, that never happens, but as I have said before, I'm an oversight hawk. So but I agree, like to the extent that we can create kind of a TRO type process in this vein, that'll both figure out what warrants that level, what warrants is maybe, like you said, more intermediate level, and make sure everyone has due process. Okay, I think on this one, we'll workshop it and come back. Why don't we move to the next proposal?
Okay, so grant awards, reductions and or terminations. So there's several scenarios when grant awards may need to be reduced or terminated. Some are initiated by grant recipients, some are initiated by staff, and some are initiated by the commission. Some of these are administrative in nature, and some require additional commission oversight. One second. I see Shannon's got a hand raised.
Hi, yes, there's another public comment request.
Shannon, can we wait until after Heidi gets through this one, and then we'll entertain the public comment?
Will do.
Thanks.
So the working group wanted to clarify the process for reviewing and approving funding reductions and terminations, and they thought it's sort of breaking it down by the initiating party, and then also clarify factors for the commission to consider when contemplating reducing or terminating a grant agreement. So here, this is sort of the considerations that are the process that the working group was considering. That staff may review and approve the following grant reductions and terminations. So sometimes the grantees initiate these, whether they're ceasing operations or they're no longer serving a specific county under an EAF or IOLTA grant agreement. They don't want the full amount of the formula request. If they are requesting a reduction in the competitive, I apologize, I've got this twice, the competitive grant-based reductions of 25% or less. Staff sometimes initiate grant reductions when it's discovered either through a monitoring process or evaluating a grantee that their formula award was based on a qualified expenditure that was miscalculated, either for not fully deducting some non-qualifying expenditures or other reasons. And then the commission oversight of the grant award reductions and terminations would be to review and may approve any grantee initiated reductions to competitive grants of more than 25% of the grant award, to review and approve any grantee initiated reductions that were not approved by staff. And the commission can determine a termination or reduction if that will affect future competitive grant awards, and they may reduce or terminate a grant if warranted. So the legal service community or legal aid community feedback came back also questions over open-ended languages, such as over other factors as deemed appropriate. They request clarification on the potential for impacting future funding. They did have questions regarding the thresholds used for budget modifications and carryover and its impact on this rule, because we were using that same 25% threshold that is often referred to as a demarcator for staff approval of roll or budget modifications and carryovers. And they also requested clarification that there would be an appeals process. And so the working group did go back to the rule and revise paragraph 6 to include specific factors for the commission to consider when terminating or reducing a grant. And they also deleted the other factors deemed appropriate language. They did clarify that the potential impact on future funding was limited to competitive grant processes, and updated the rule to reflect that it was only for those competitive grants where these types of changes could be a factor in funding determinations. We clarified that the working group felt that the 25% threshold was an appropriate level of oversight despite the ongoing review of the budget and carryover codification topic, and it clarified the reconsideration process for funding reductions and or terminations. So I can go to that rule and we can read that rule. It's a little longer. And so I'll defer to you, Erica, on the public comment question. Do you want to take that now?
Sure. Why don't we take that now while people review the rule?
And then at a certain point, I will roll to the next section of the rule since it does go past one screen.
Sure.
Mr. Hill, you should be able to speak now.
Hi, Erica. My apologies. It's no longer quite on point because I was going to refer to something that you said at the end of last commentary. So forgive me for that. It's not quite my fault. But that said, you mentioned remember due. You mentioned remember due process, but I will remind folks, because this is a formal tribunal, hearing of the tribunal, that due process is not actually the standard the bar is required to operate under in this context. It's reasonable process likely. But none of the processes, including state bar court, are actually reflected in due process. I just want to be clear about that. Thank you.
Okay, thanks, Mr. Hill. We're trying to ensure that our grantees get adequate process, but I appreciate the comment on it. All right, are we ready to scroll down?
We'll go again.
So number 5, okay.
I'm sorry, is that too far?
Okay. Well, it's just, I think number 5 didn't show before even.
Oh, didn't? Okay,
number 6. So you may reduce a formula grant if the grant recipient or staff determines that the organization's qualified expenditures. Oh, we're incorrect. Okay. So you would determine that after you already gave the grant that the qualified expenditures were incorrect?
This
yes,
does
so
happen occasionally because they submit a wrong audit or they come back and their programs are very forthright with us about that they should have counted something. So we have recalculated in the past.
Or during the monitoring process, if it's determined that they should have excluded a non-qualifying activity, for example, there have been examples where grant amounts have been calculated based on the monitoring process.
But if the monitoring occurred 3 years after that, how do you modify the prior grant that is already spent?
Well, in the monitoring process, we're usually looking at the year before. So depending upon when the monitoring, like I have a situation where I'm doing it right now where we're looking at the application data that was used for the current grant year we're in. So if that were discovered going back retroactively to 3 years ago, I'm not sure how the commission would decide to handle that issue, but right now it's examples that we have are it's in the concurrent year. And that rule 5 just is kind of existing office practice now, and it's just codifying that existing office practice. Is everybody ready for me to roll up a little more? Hearing nothing, we'll go forward. I don't know if you could see could you see 7 before?
No.
And I'll roll forward.
Yeah, so I guess that's the question, that the 4th bullet of that one, right, was what?
25%.
Yeah, is what the legal aid community was asking about, right? So what grant, so this is, but the grant recipients requesting a reduction. So I'm fine. If the grant recipients reduction, I'm fine. That's fine.
The threshold, I don't believe that the legal aid community, well, they just asked about.
No, I was mistaken. This is about if a grant recipient is requesting any of these things, should staff have the ability to approve it? Absolutely. That makes sense to me. I don't think there's a dispute.
Okay. So then, and then this is the last of it.
And for this one at number 8, just want to note that in the posted materials, the word approved was mistakenly taken out. So we're just putting it back in here because it wouldn't make sense without that word.
Thank you, Elizabeth. I meant to mention that. Yeah.
But and under A, is it competitive based grant reductions that are greater than 25% requested by a grantee, or any of them?
Yes, this is, so I could, we didn't, we could use this same language here and just change it to more than 25% so that it mirrors that for the commission, I think.
Well, I just think it's important if the intention is that it's a grantee requests something, like that seems helpful there.
I'm going to just copy this and just change it to the, just mirror that. I'm sorry, I'll let you see that.
And the staff initiated ones are based, I mean, the example that I recollect was there were a determination about qualified expenditures. Is that the only thing we're
That's the only staff initiated one, yes.
And the commission ones are just the things in.
Well, the commission has the authority to reduce or change or terminate grants. So this is just, you know, sort of outlining sort of what, you know, that it might have, that there might be additional, you know, requirements based on if the commission chose to reduce a grant or terminate.
So is there an intersection between the prior rule that we were reviewing and this section number 9 then?
Well, there is this, to delay future grant distributions. That's the intersection to that prior
one. Will, you have a comment?
Yes, I was wondering, because I'm not sure I'm entirely clear on this rule, whether the funding will continue month to month until it comes before the full commission. So no one's getting a reduction.
That's statutorily required.
They've had a chance. Okay. I just wanted to make sure that that was still incorporated, and thank you very much.
Other questions, comments on this? Heidi, can you scroll down really quick with the asterisk?
Oh, it's referring to this, which we could change the asterisk from the rule to the delayed one to the code section, the business and professions code section.
I think that actually might be
better. I can't see I'll insert a footnote. I can't, hold on, my workbook is there, my toolbar is in the way. Okay. Oops, no, hard. Sorry, where's the footnote? I forget where it's references, right? Okay, it's do you know what that, I know somebody said the code section number.
6224.
Thank you. Mm-hmm. And I'll go back and make this a 1 because there's another one. When we separate it out, it will correct that. And I will strike this.
So I'm trying to look at this rule on my computer so I can see it. Is this rule include attachment C, which is the
this is attachment C, yes.
So there's this grant recipients must return to the state bar any unspent fund or relinquished funds, and then it says as defined in some unnamed rule. Is that what you're talking about?
That'll be rule D. We'll get to next.
Okay. And then the number six is an overarching authority, or it's just related to the things that are, I guess that's the commission just may generally reduce grant awards or terminate grant agreements is a general authority that
it is in 62.2. It's the general authority that's under the code section. And so this is just clarifying what factors would be considered if the commission were to exercise that authority.
Which are the same factors that we talked about in the prior one, right? In the prior rule.
Yes, we use the same factors in both examples.
But are we going to try and clarify any of those factors when that rule goes back, as Erica said, to workshop it, or?
Well, we've done our best to try to be as clear as we can without, sort of preventing the possibility of, future things that we cannot predict. So.
Patience, go ahead.
So the problem with the prior rule was that the impact would be accelerated, and it wasn't clear what sort of process would be provided. And this is I see this as a much less, this is not a TRO, this is the permanent injunction. So there's plenty of, everybody, there's conversation, there's whatever there's going to be. So I honestly, first of all, nobody's got any time, but apart from that, this doesn't really seem to me to be, as an executive director, I would not look at this and go, oh, well, they could just do anything they want for no reason. This describes red flags that a program should be able to avoid. So this doesn't feel to me like the deficiencies have the same impact. If they are, I don't see them as deficiencies here.
So I think the only one I have a question about is the significant underspending, which we've spent a lot of time on kind of throughout the discussion, right? So if the underspending is defined the same as the 25%, I guess I see that as a potential problem.
I don't think anybody anticipates significant underspending to be defined as 25%. That's never been, that's not been part of our conversation. I would say like the significant underspending, where that example where we did have that HP2 funds where there was zero spending in the first 2 years, and the commission went in and made it sort of a requirement of the grantee to provide certain levels of, or certain performance things before they would allow them to continue on in the third year. So I think that was, I don't think significant underspending anybody would define as 25%. Don't think that's a.
I guess that's my point of definitions. Is there a definition of what significant underspending is?
There is not right now, but would it make you feel more comfortable with it if there was a definition? And if there was, what would be the threshold that you think would be something that would be palatable?
So if the example is certainly like, it's fine, like if you haven't spent any of your money, then you could terminate the grant because you're not performing presumably the work under it. But it's got to be like, I don't know, 6 months or more underspending, something like that, because it seems like these can apply to any of the grants that the trust fund administers, these rules, right? Unless I'm misunderstanding this. So you could...
Yes, no, you're not. I mean, I think the idea is like, even if a formula grant had a bunch of money and was just, the formula grants are a little trickier because there is sort of statutory right to it. So I'm not sure, but again, like there is some statutory right for us to terminate it depending on certain factors, right? I'm not sure if significant underspending, I can't remember what 6224's requirements are, but Oh, because they're not operating in compliance with the requirements of the Business and Professions Code. So that's the flip side of it, right? You have a right to it unless you're not actually doing what the Business and Professions Code requires, at which point we are allowed to terminate it, right? So, so I guess, like, I'm happy to like have us revise that, but I don't want to go back and take a stab in the dark at like what would actually get us through the rules committee. So is it like 50%? When you say 6 months, I don't know if that means like 50% of the grant, or like they're not reporting to us every month for each, every month that whether they're spending or not. So we can't necessarily know 6 months or not, right? So, I mean, on the formula grants, I think they only report their expenses. Quarterly. Actually, I don't know, Heidi.
I think IOLTA and EAF are reported quarterly. HP3 and Cal HFA, because they're federal, are also reported quarterly. Everything else is annual.
Okay. I mean, and also time is only part of it, right? Because if you only underspent 10% in the first quarter and 20% in the second quarter, like you've underspent, but is 2 quarters enough? Seems to me that it's more like size of the amount. I would tend to think 50% sort of makes sense, but I've not been an ED, so I don't know whether that's not realistic. If it's realistic for people to not spend 50% of their grants in the, first 2 or 3 quarters,
Well, I think it depends, like in this move to like, right, we're moving towards a multi-year budgeting. So not spending 50% would make sense if you had budgeted over a 2-year or 3-year period, right?
Sure.
Because otherwise you'd run out of money.
But also, is the money all going out in the first, year or not? I mean, that's the other question.
Oh.
I don't know whether in the multi-year, I assume I don't know whether
they go out in annual disbursements typically.
That was Catherine's point earlier, that if you've got to hire lawyers to execute this grant to deliver on it, then that might be month 7 by the time you actually hire a lawyer, and then that's when your personnel costs kick in. So yeah, it's not at all unusual for there to be a ramp up period that could be quite long, actually.
Well, so I'm happy. I mean, the other thing too, I'll say is like, we can set a bar with like that creates the presumption of a problem. That doesn't necessarily mean that the commission has to actually delay or terminate the funding, right? Like we could say, if you haven't spent whatever, even I'm just picking a number here, 75% within the first year, right? Like that may be too generous, but right, like that at least gives us like a reason to start looking at whether you ought to have your funds reduced or terminated.
Unless it's a multi-year budget, right? So
sure.
So it's almost of what you've budgeted, maybe. I don't know. I don't know what the right words are, but that's the part of it that makes me nervous in this, to say sort of like you're an ED and you could have your entire grant terminated because you had underspent. And
but I don't see this as that. It's
okay,
like
perfect.
The commission has authority, but that, again, we're describing a trigger point for an inquiry, not a criminal sanction for an action. So I'm not seeing this as the kind of draconian, maybe, I don't know, the kind of scary. I am going to have to step away from this meeting. I'm sorry. I have another meeting in 7 minutes.
Okay.
So.
Yeah, sorry. I was trying to be good on time, but I think we're not even going to finish this in time. The point I think is just more generally that I hear you. I would like some input on what what significant underspending should be defined.
So did the programs provide some input about what that should be? I thought they had some concern about.
The feedback that the programs spoke to had related to this distinction of the staff not being able to approve reductions of competitive grants over 25%. That was the comment was related to this threshold. We did not receive any feedback on this section 6, except for we had a I think there was a little language that was a little loose, and so we tightened it up. And so I also want to point out that these are just things to consider. These aren't, automatic. So it isn't, these are just things that the commission would consider and then would have in a public meeting, a discussion over. So it's not so, you underspend, your grant's gone. There is a due process, and these are just considerations. I hear Jim's got his hand raised.
Were some of these issues discussed when we were going back through and defining what carry forward was between a yearly grant versus a multi-year grant, and requiring reviews of multi-year grants at the end of each year? I mean, I can appreciate the sentiment of this, because I was chair of a committee where we had a multi-year grant that they weren't spending any of the money. And it created all sorts of problems because we weren't set up to review multi-year grants, and we didn't have the verbiage and the rules and so on. But I think some of this stuff is going to be caught with the changes in the rules. And I forget what we used. There was a term, on a multi-year, there was a special term we used. Rollover versus carry forward. That's right.
Just so you know, Jim, right? Those are all getting upended, and we're starting from scratch with the carryover and the budget modification, because the last rules committee, there was sort of this concern about multi-year and should we be actually more flexible about it. So I just caveat that, like, yes, these are in dialogue with each other. And yes, we did sort of address that in the carryover in the budget modification committee, the working group, but that's now we're rethinking that entirely too. So I like I said, I'm happy to workshop this, but I'm not, we can ask LAC if they have views, but Catherine, if you also, or other people in the committee have views on like what significant underspending, or whether you think it should just not be in there at all and we should address it in a different way, like that may be the solution. I don't know, but I don't want to just say like, this is a problem. I want to try to come up with a workable solution to it too, right? Because otherwise I think, other than significant underspending, is there any other concerns with anything in there?
And maybe if LAC doesn't have concerns, then maybe I'm the only one with concerns. So like, maybe if they have input now or input later, I don't know. I know everyone.
Yeah, I don't know if Zach is on the
with time, so.
Yeah, Zach or Lauren, if you guys have.
Yeah, no, we actually didn't hear that much on this one, as was kind of described and was included in the attachment. But I think if it's worthwhile, we can obviously get more input on this specific matter. I think based on Catherine's concerns, I feel like they're pretty well taken, of course. And if there is room to get more community input, specifically highlighting this issue, that could be worthwhile. But yeah, as I said, and as you can see in the memo, it wasn't anything specific on this except for the 25% stuff.
Are there any other concerns from other people on the committee on this particular one? Is the consensus that we should continue to workshop significant underspending, or should we move forward?
Can we define it later, do you think? So we can...
I mean, we can put it, I think some of the thought was we put it in this administrative manual, and like, then there's some flexibility on it, right? Depending on kind of if you move back from a multi-year where there's tons and tons of money back to the dry years, that's another option we could do. And one of the things we could do is put in there some footnote or something, see the administrative manual for guidance on what this means. Maybe we do it that way.
I think I'm fine with that, just so that there's some clarity about it. All right, so I am being kicked out of the room that I rented, so I had a public location. So apparently they're moving me to another place.
Got it. Good luck. Thank you as always for your very useful feedback and very useful. I know we sometimes butt heads a little bit on our thoughts on this, but I do really appreciate all of your views on this. It's very helpful to make the rules.
All right. So do you need me to vote for this, or you're all good?
If you're up for it, let's vote for it. I'll make the motion.
And it's going to be with the definition of significant underspending in the admin.
Yeah, can you throw in a footnote in there, Heidi?
You want me just to say,
see the administrative.
It's fine. You can add it after we vote. We completely trust you to.
Okay. Yeah, but yeah, something like see the administrative manual for guidance.
Well, is it problematic approving it with language in it for something that doesn't exist?
It will be defined.
Subject to, the resolution is subject to the administrative manual.
Okay, so I'm going to put that in the resolution, not in the actual rule itself then.
Yeah, that's fine.
Okay. I second.
Okay, let's take our vote.
All right, who was that who seconded? I know Dawn.
Vanetta.
Thank you. Okay, so I'll go on and take roll call vote, Erica, since Dawn had stepped out. Al-Saraf? Fightmaster?
Yes.
Blakemore?
Yes.
Shelley? Oh, Campbell?
Yes.
Galkin? Meeker?
Yes.
Milrod?
She stepped out.
Connolly?
Yes.
I believe motion passes. Let me just step there. Shannon, sorry, apologies. I don't recall I don't know the quorum number for the votes for this committee. Shannon's still on?
Yes, I'm here. 1 second.
I want to just think before I confirm that. Okay, quorum is 5 and we have 6 yes votes. Okay, motion passes.
Great. Okay, thank you all for very good discussion. And we'll work on the admin manual, and that will be useful for the other one that we're going to workshop as well. Okay, and that may be the way that we do it. Heidi, are you, and Crystal, are you okay if we move the last one to next month, given that we're at time? And I know there's sort of other big meetings. Okay. Committee, thank you all, as always, very helpful. And this is like our trial by fire, our crucible with these various rules. And so thank you for your patience and good luck with everything. And we'll see you all in October, I believe is the next one. Awesome. We'll have more new rules. So exciting. Have a good one. Bye, everyone.
Thanks, everybody.